Now the session, the Honorable David L. Williams presiding. Make sure all yourself on off. Very hit alongside prayer.
Before we do that, I want to, everybody say, I want to announce that the moment of silence today includes the loss of a valued member of our court family. Mrs. Staten, who, is passed away unexpectedly, Diane did. So let's remember her family, our moment of silence. Thank you.
Alongside prayer. Thank you, may be seated.
Thank you very much. Commonwealth versus Mitchell Comstock. Yeah, prisoners up here yet?
So I heard those medical records, so
Commonwealth Kentucky versus Mitchell Comstock, 25 CR 0013. Are you Mitchell Comstock? You born, let him behind the podium there, okay? He's the star right now. Were you born in 1967?
Yes, sir.
Last four digits of social security number 8279. You're here for pretrial conference. What does the Commonwealth have to say?
Judge, I think we need to get a trial date on this. I was just looking to see if all the medicals, had to go to the hospital, let's make sure all the medicals were here local. They are, so. Yeah, so medicals are local, so we just need to get a trial date.
What's the charge?
You have an assault, wanton endangerment, theft. I just asked to try all of them together. It's all out of the same incidents.
Okay. Look at your calendars for April 28th, 29th, and 30th. What's going on? We don't have any of those days. Is there some reason?
30th, I have a mediation. 29th.
What does the 29th look like for council?
I'm okay. The 29th works for me, Your Honor.
I need to sign.
You need to spend some more time with me. Explain all this stuff. I'm gonna sit down here until 1 month the next week. Just for my discovery package.
It went up here to celebrate.
Yeah.
Okay, Billy Cranfield.
You will, what, next month?
Billy Cranfield. Are you Billy Cranfield? We're on Commonwealth Kentucky versus Billy Cranfield, 24 CR 0084 for pretrial conference. Mr. Cranfield, were you born in 1979?
Yeah.
Last four digits, social security number 2.
74.
You wouldn't, what year were you born?
74.
74? Okay, I got a misprint here. Last four digits, social security number 2029.
Yes, sir.
What does the Commonwealth have to say on this?
We have diversion plea on.
I've just been informed, sir, that you wish to enter a plea today. Is that correct? Are you currently under the influence of drugs or alcohol?
No.
Is this plea freely and voluntarily given? Are you the same person you just identified in 24/0084? Is your judgment impaired today in any way? Okay, have you discussed this matter with your lawyer and are you satisfied with his advice?
Yeah.
Have you reviewed the evidence the Commonwealth has against you? Believe you're fully informed about your case? You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky and United States Constitution. You have the right not to testify against yourself. No one can make the same thing. You have the right to speak trial by jury, right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses called to testify against you, right to produce evidence, the right to call witnesses in your favor, right to appeal this matter to a higher court if you lose, the right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of the charges against you. Understand that by entering a plea today, you give up those rights.
Yes.
Now, I may consider the Commonwealth's recommendation, but I may apply in the range of sentence allowed by law. I don't have to accept the recommendation. In the event that I do not accept the recommendation and decide to impose a harsher sentence, you have the right to withdraw your guilty plea and proceed to trial. You understand that? And I'm going to do some qualifying questions. Have you previously been diverted in the last 5 years?
No.
Have you had any felonies in the past 10 years? Are you currently on probation? Do you understand that if you fully complete the diversion program, the charges will be dismissed? And you could, as pretrial diversion, you have your record expunged. Do you understand that? However, if you do not successfully complete the diversion program, you'll be brought back in front of me and the court will schedule a sentencing hearing if I find that you violated it. What is the Commonwealth's recommendation, Ms. Gordon Anderson?
Yes, Your Honor. Upon a plea of guilty to possession of a controlled substance, first degree, first offense, methamphetamine, the defendant shall receive a sentence of 3 years, pretrial diverted for 5 years, supervised. The defendant shall enter and complete the Clinton Specialty Drug Court Program and follow any and all recommendations. The defendant shall receive credit for time served except for contempt time. The defendant shall be released from incarceration the morning of orientation or at the discretion of the court as regards to contempt. The defendant shall obtain gainful employment or do a minimum of 30 hours of community service per week and until gainful employment is obtained. The defendant agrees to have any and all evidence in above style cases disposed of in a manner that's consistent with the laws of the Commonwealth and the holding agency.
Is that what you agreed to?
Yes, Your Honor.
Are you pleading guilty because you didn't commit the acts in the indictment as amended? You're doing so of your own free will, knowing your constitutional rights to explain to you, but it's still your desire to give up those rights and enter a guilty plea or allow the court to fix your punishment.
Yes.
Okay, you realize that if you violate the pretrial diversion terms and I come back in and order pre-sentence investigation for you, you'll be a convicted felon if that happens. And that could be used against you in the future. You understand that? Is that your signature on there?
Yes, sir.
Now, Mr. Stockton, is this he's supposed to stay in jail till he gets oriented?
That's correct. I think it's this Friday or tomorrow. Is that right, Mr. Cranfield? Yes. Tomorrow.
So make sure we get an order submitted to let him out so for the orientation, okay? Okay, thank you very much.
Thank you.
Justin Daly. Justin Daly. Commonwealth versus Justin Daly, 24 CR 007079. Good morning. Are you Justin Daly?
Yes, Your Honor.
You were born 1989. The last 4 digits, social security number 6037. You're today for a pretrial conference.
Your Honor, this case is free consent for trial history, I believe.
Yeah.
We learned, I was only able to meet with the victim in March, to learn there's like 4 different healthcare providers she's been to as far as therapy.
Yeah.
And I've got an agreed order to get those records, and when I get those, I'll furnish them to Mr. Russell.
Okay. And you just want to have another pretrial?
If that's fine, maybe next month we'll get a trial date if we get all the records.
Okay,
Yeah.
let's, that would be May the 8th. You want to negotiate
Yeah, let's set it for the first so we can get a status on it.
so it'll be May the 1st for a negotiation date and May the 8th for the trial date.
Thank you, Your Honor.
Madam Clerk. Nathaniel Johnson. Nathaniel Johnson. Commonwealth versus Nathaniel Johnson, 25 CR 002. Good morning. Are you Nathaniel Johnson?
Yes, sir.
Were you born in 1986?
Yes, sir.
Last four digits, social security number 9661.
Yes, sir.
We're here for a pretrial conference. What does the Commonwealth have to say?
We would have a felony plea, is that correct?
Yes.
Okay.
Just have been informed that you filed a motion, says you wish to enter plea today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol? So is this plea freely and voluntarily given?
Yes, sir.
Are you the same person we just identified in 25 CR 002?
Yes, sir.
Is your judgment impaired today in any way?
No, sir.
Have you discussed this matter with your attorney? Are you satisfied with his advice?
Yes, sir.
Have you reviewed the evidence the Commonwealth has against you, believe you're fully informed about your case?
Yes, sir.
You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky United States Constitution. Before I can accept the plea, I'm going to go over your rights and at the end, I'm going to ask if you understand. You have the right not to testify against yourself. No one can make you say anything. Right to speak, trial by jury, right to be represented by counsel at your jury trial. Right to confront and cross-examine all witnesses called to testify against you. Right to produce evidence, right to call witnesses in your favor. Right to appeal this matter to higher court if you lose. And right to be part of the Commonwealth, prove beyond reasonable doubt that you're guilty of charges against you. You understand by entering a guilty plea that you give up those rights.
Yes, sir.
I may consider the Commonwealth's recommendation, but I may apply the range of essential provided law. I don't have to accept the recommendation. Prior to accepting the recommendation on your plea, I will await a pre-sentence investigation report to be done with probation and parole. In the event that I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea. Ms. Gordon Anderson, what is the Commonwealth's recommendation?
Upon a plea of guilty to burglary, second degree, the defendant shall receive a sentence of 5 years to serve. Upon a plea of guilty to theft by unlawful taking or disposition, the defendant shall receive a sentence of 12 months to serve. These two sentences shall run concurrently for a total of 5 years to serve. The Commonwealth will oppose probation and shock probation. The defendant agrees to have any and all evidence in the above style case be returned to its rightful owner or disposed of in a manner that's consistent with the laws of the Commonwealth and the holding agency.
Is that what you agreed to in your understanding?
Yes,
Are you pleading guilty because you did commit the acts
yes, sir.
and you're doing so of your own free will?
Yes.
Your constitutional rights have explained it's still your desire to waive those rights and allow the court to fix punishment on your plea of guilty and within a range of by law. You know, is that
Yes.
correct? Do you understand that any, because of this guilty plea, any future convictions could be enhanced under persistent felony offender law? Do you understand that?
Yes, sir.
That's your signature on the document.
Yes,
I'll accept the agreement order pre-sentence investigation report and schedule sentencing for May the 8th.
Thank you.
Dale Parales. Commonwealth versus Dale Parales. 24 CR 0094. Good morning, sir.
morning.
You are Dale Parales.
Yes, sir.
Were you born in 1962?
Yes, sir.
Last four digits, social security number 9360.
Yes, sir.
You're here for a pretrial conference. What does the Commonwealth have to say about this case?
Felony plea,
Okay.
Your Honor.
I didn't hear.
You need to give him the earphones. Let me get you some earphones. Okay. The acoustics aren't too good in here and I've got a little raspy voice today. We'll get you some earphones. We're here. Okay, is that better?
Yes, sir.
Okay. A motion's been tendered that says you wish to enter a guilty plea today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No.
Is this freely and voluntarily entered? You doing this freely and voluntarily?
Yes.
Okay. We just previously identified you in 24 CR 0094. You're the same person.
Yes.
Is your judgment impaired today in any way?
No.
Have you discussed this matter with your attorney and are you satisfied with his advice?
Yes, sir.
Have you reviewed the evidence the Commonwealth has against you? You believe you've been fully informed about your case?
Yes.
You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky United States Constitution. Before I can accept the plea, I need to know that you understand those rights.
Yes.
I'm gonna go over it, then I'm gonna ask you to understand, okay?
Yes.
You're right, not testify against yourself. No one can make you say anything, right to speak, not a jury, right to represent the counsel at your jury trial. You have the right to complain, cross-examine all witnesses, call testify against you, right to produce evidence, the right to call witnesses in your favor. Right to appeal this matter to higher court if you lose. The right to part of the Commonwealth plea beyond a reasonable doubt that you're guilty charged against you. Understand that by entering a guilty plea, let you give up those rights. You understand that?
Yes.
I may consider the Commonwealth's recommendation, but I may apply the range of sentence allowed by the law. I don't have to accept the recommendation. Prior to accepting any recommendation, I'll order a pre-sentence investigation report. Be done the probation parole. After review of that, if I decide not to accept the recommendation and decide to impose a harsher sentence on you, you have the right to withdraw your plea and go to trial. You understand that?
Yes.
You step to your left, sir. Ms. Gordon Anderson, what was the Commonwealth's recommendation?
Upon a plea of guilty to rape third-degree vulnerable victim, the defendant shall receive a sentence of 2 years. Upon a plea of guilty to sexual abuse first-degree vulnerable victim, 2 counts, the defendant shall receive a sentence of 10 years on each count to run concurrently for a total of 10 years. The 2-year sentence and the 10-year sentence shall run consecutively for a total of 12 years to serve. The defendant shall have no contact with the victims. The Commonwealth opposes probation, shock probation. The defendant agrees to have any and all evidence in the above style cases disposed of in a manner that's consistent with the laws of the Commonwealth and the holding agency.
Sir, you want to move back over to your right? Is that your understanding of the Commonwealth's recommendation?
Yes, sir.
Are you entering this plea because you committed the acts charged in the indictment?
Yes.
You do so of your own free will.
Yes.
Knowing your constitutional rights as explained, is it still your desire to give up those rights and plead guilty and allow the court to fix your punishment within an arrangement by law?
Yes, sir.
Do you understand that by entering this plea of guilty, any future conviction could be enhanced under the persistent felony offender law?
Yes.
You also understand, in all probability, well, factually, there's a sexual offender registry that you would have to be in upon. You understand that?
Yeah.
Is that your signature on the docket there?
Yes.
Okay, on the agreement, whether I accept the agreement or a pre-sentence investigation report in a sexual offender.
Yes.
Yeah, it'd be June the 18th. Okay,
Thank you.
thank you very much. Jimmy Pointer. Jimmy Pointer. Commonwealth versus Jimmy Pointer, 25 CR 008.
Okay.
Good morning. Are you Jimmy Pointer? Can you come over and stand behind the podium here? Were you born in 1986, Mr. Pointer?
Yes, sir.
Last 4 digits, social security number 8306.
Yes, sir.
You're here for a pretrial conference. What does the Commonwealth have to say?
Well, we thought we had a plea, but
Come on up here where I can get you on the camera.
he's not going to accept it.
Yeah, you can get behind the podium there. So y'all had
We had a plea worked out, I thought.
okay, well, you want to set a trial then?
Yes, that'd be fine.
Well, stay here with me just for a
I need
second.
to get my count.
I know, but what kind of case is it?
It's a criminal mischief, wanton endangerment.
So it's a 1-day trial.
It's 1-day
Okay, get your calendar, come back up here.
I mean, he's not good at crime.
Look at May the 9th. Right,
Go back a little further, but I don't know.
Yeah, we can go out.
Just me and this Gordon Anderson, I'm trying to case it. I don't know about it.
yeah, well, the only thing is I'll give him some priority since he's incarcerated, you know, I'll give him, okay, on the 13th, we got a Cumberland County trial that has versus Molds.
He's incarcerated.
Yeah, and then we've got Commonwealth versus Shaw on the
Is Shaw
14th.
incarcerated or do you know?
Well, what about the 16th? That's a week farther out.
That's fine.
Yeah, that's fine with me.
I'll check.
All right, yeah. Watch your hands, me.
Judge, we set May the 1st also for negotiation.
What's the deal?
I don't know, there's some of the terms aren't satisfactory, so I'm.
Well, I mean, we'll try it. Let the jury decide what the terms are, okay?
Yes, Judge.
That's enough. Six months, Friday.
Grand jury. Because I think that he brings it. He's been time later. Yeah, as soon as I get down to jail, I'm there. That big. Picked up Maximus.
Okay. Colton Randolph.
But Your Honor, one last thing with Mr. Pointer, if you don't mind, is his mother was in the ICU. I think she's just now getting transferred back, and he's her primary caretaker. And we were wondering if we could do anything about his bond.
What is the charge, Mr. Stockton?
It's wanton endangerment, criminal mischief. Evidently, there was an altercation at the home, and Mr. Pointer allegedly drove a car into another car, and there was some people into it, but it wasn't a major collision, but it was a collision, my understanding.
What was it proposed plea?
It was probated with restitution. And drug court.
Well, you convinced Mr. Stockton of it and bring it over. I'm not going to just do it right off the edge because I don't know anything about his criminal record. It's not in front of him today. What kind of criminal record is it?
His accident is moderate.
Can you speak up a little bit?
Sorry. His accident is moderate. His DCA is moderate as well. I'm going to let this mystery right now. It's even moderate.
Well,
I told him, that's not gonna be very good.
yeah, started PFO and other things. I'm not gonna be able to do that. So,
Okay.
okay, thank you very much. Colton Randolph. Colton Randolph. Good morning. Are you Colton Randolph?
Yeah.
This is 24 CR 0087 Commonwealth Kentucky versus Colton Randolph. Are you born in 2006?
Yes.
Last four digits of your social security number 4446.
Yes, sir.
We're here for a pre-trial conference. Mr. Stockton, what do y'all have to say on this case?
And I've spoken to the Commonwealth attorney in Pulaski County. And if we have a trial, we want a trial of it down here. So plea and evading begins in Pulaski.
If you get behind the microphone.
And went through Wayne County. So I would have to either transfer the case down here or do the Somerset indictments down here. And we've made some offers back and forth, but I think I need to get in position to trial before we.
I think the criminal rules allow consolidation of cases when they have common.
Well, I guess what I'll do is I'll just file a motion to have it transferred down here.
For judicial economy, that way you want it to defend the man in three counties.
I don't know what their position is going to be.
You agree to that? Just transfer it down here.
And I would imagine, I don't think my client wants that.
Well, we'll have a motion and I'll decide that then. Okay. Decide on that issue. When you want to schedule this, Mr. Stockton?
Just schedule for the next rule day. We don't need a negotiation. I'll just file the motion.
Okay, that'll be fine. May the 8th. Okay, do y'all have anybody else in custody? Is that it?
That's it, sir.
Okay, thank you very much. Yeah, okay, let's go to the out of custody situations. I'll try to, any of you out of town lawyers that are here, if you've got out of town custody, please.
Your Honor, we call Josh
How
Town.
many do you have?
Your Honor, I have one on for arraignment and one on for sentencing, and
And what
I'm
do you-
actually.
What do you have? So let him do it.
Sure.
We got farther drive than you do. What's your client's name? Commonwealth versus Brett Carter. Now, who's involved in this other case that we had the suppression for tomorrow? Is that attorney here?
Mr. Bragg.
You know, don't let us forget that because there's something coming. We got an officer unavailability situation.
Yes, I've been talking to Mr. Stockton about that.
Okay, Commonwealth, Kentucky versus Brett Carver, 25 CR 0017. Are you Brett Carver?
Yes, sir.
You born in 1976?
Yes, sir.
Last four digits of your social security number 5893.
Yes, sir.
Here, the purpose of arraignment, you got a right to remain silent. If you have any questions, please step away from the podium. The grand jury of Clinton County is returning an indictment.
Judge, we'll waive formal reading.
I'm gonna do it the way I do it anyway. Y'all, when you're up in Marion County, you do it the way you want to. I'm gonna do it my way here, so it'll be on the record, okay? I'm gonna wait formal reading. The grand jury of Clinton County has returned an indictment charging with theft, unlawful taking disposition, or complicity, theft, unlawful taking disposition. Charge one, and charge two is unlawful access to computer first degree, or complicity to have unlawful access to computer first degree. You acknowledge the identity of your client,
Yes, sir.
the receipt of the indictment,
Yes, sir.
waive formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions. Okay, you want a negotiation day on this?
That'd be fine. I think Mr. Lamb's gonna file a motion. We need to get his email so we can send you discovery.
Okay, if you'll give it to him, we just, when we finish here. Will y'all be ready for a pretrial, for a negotiation day on May the 8th, or is that too early?
I think that may be fine.
Okay, May the 8th, no, May the 1st, right?
That's correct.
May the 1st is a negotiation day, and the next court date is May the 8th. No complaints about his bond, he may be continued on the same bond, is that correct?
I think that'd be fine.
Okay, thank you. Yeah, you need to enter your appearance. Are you entering for Mr. George and yourself?
I'm entering for me, just this time.
Okay, well, state
Mr.
your
George
full
may
name.
enter at some other point.
State your full name,
Jonathan Lanham,
just so it would be on the record.
it's LANHAM.
Okay, thank you. Okay. Who do you have?
Josh Talent. And Your Honor, I would note for the court that I am standing in today on behalf of Mr. Cross.
Joshua Talent. Commonwealth versus Joshua Talent. 25 CR 0028. Are you Joshua Talent?
Yes, Your Honor.
You born in 1989?
Yes, Your Honor.
Last four digits of your social security number 3393.
Yes, Your Honor.
You're on a pretrial conference.
I believe it's on for arraignment, Your Honor.
Just on the docket wrong, so. Okay, you have a right to remain silent. You represent by counsel. You're going to, if at any time you have any questions about what's going on, step away from the podium there and ask your attorney, okay?
Yes, Your Honor.
Okay, the grand jury, Clinton County has returned an indictment charging you with improper use of blue lights,
Is this Mr.
expired plates, possession of drug paraphernalia, controlled substance, the first degree of possession, and possession of marijuana. Do you understand those charges?
Yes, Your Honor.
Counselor, do you acknowledge the receipt of indictment, the identity of your client, waive formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions?
Yes, Your Honor.
Okay, I'm just doing the reciprocal discovery order. There'll be a negotiation day on May the 1st, and then the next court appearance is on May the 8th.
And Your Honor, as I said, this is Mr. Cross's case. I'm filling in for arraignment only, so he would be here for the remainder of the case.
That's good. Thank you. And then you got someone else?
Your Honor, if I could have 1 second.
You want to call your case? Yeah.
Judge, he's in Russell County, he's supposed to appear on Zoom.
Okay. Okay, Amy Burchett. Commonwealth versus Amy Burchett. Good morning.
Good morning.
22 CR 0051. Are you Amy Burchett?
Mr. Your Honor.
Were you born in 90?
Yes.
Last four digits, social security number 5052.
Yes.
You're here on a probation application. What's the Commonwealth have to say?
Your Honor, I've kind of been in the loss in this case, what to do. If you recall, Miss Burchett had several drug violations. She was placed into drug court. When she went to drug court, she was terminated because this is the one we had the long hearing on where she was co-sleeping with the minor, with her little young baby. Then she did pretty good for a while. Now she's had another meth test and a gabapentin positive. And that's the same drug she was on earlier.
Yeah.
So that's the reason I filed the motion to revoke. She was evaluated to SSC for outpatient, but I don't know if that's sufficient or not, since she never completed the long-term treatment before. I don't know that she ought to be revoked or go back and do long-term treatment, since this has crept back up.
And she'd be willing to do rehab, long-term treatment.
So
What kind of issues you had supervising Ms. Burchett?
I had use of meth, 2 uses of meth, the use of gabapentin. Then she attempted to alter her drug screen by drinking extra water. However, it come back from the lab diluted. But before it come back from the lab, she called in and admitted to me that she tried to dilute it.
Well, that's laudable that she fessed up before she got caught.
RSC recommended outpatient, so it's inpatient. Go ahead, because the target might find it.
What are you saying?
Our SSC recommended outpatient treatment, Sav-All-P on the street. And if inpatient is recommended, the attorney will have to find it, since our SSC's already made the recommendation.
And that's the reason I filed the motion, was because I disagreed with SSC in this based on.
Can you find a placement for this lady?
Yes, I can.
What kind of placement can you find?
I'd have to speak with a representative of Spark and City.
Well, Ms. Burchett, I'm gonna give you a break and try to find you some treatment, not to send you to jail. But you know, you're on the edge of going to the penitentiary. It's not a good thing. I know you don't want to have this problem.
no.
Yeah, so we'll go ahead and take her into custody. You take her into custody today, Mr. Stockton?
That's fine with me.
And just as soon as you find her a placement, I'll sign her out, okay? Okay, thank you very much. Christopher Connor.
Quick.
Commonwealth, Kentucky versus Christopher Connor. Are you Christopher Connor?
Yes, sir.
This is 25 CR 0006.
Yes.
Last four digits, social security number 5347.
Yes, sir.
Your attorney Shelby Crawford has some health issues in her family and she's on Zoom. You see her there?
Yes.
Good morning, Judge. Thank you for allowing me to appear by Zoom.
We also have Virginia Connor, who's here. Virginia, you come around, please. This is 25 CR 0005. Virginia, were you born in 1983? Last four digits, social security number 3171. Now, Ms. Crawford, have you had the signature of a dual representation waiver?
Yes, Your Honor, I went over that with them and signed it. So
Dual representation waiver.
we've went over it.
Get them to sign when we have them here. Y'all understand that each one of you are entitled to your own attorneys, and if there's any conflict between you, it might affect your rights. Both of you want to waive that and have the same attorney? You, ma'am?
Yes.
Okay, so we'll go ahead and do the form for you, Ms. Crawford.
Okay, thank you, Judge.
What's the Commonwealth have to say about this? You want a May 1 negotiation day?
Your Honor, there was some issues brought up by defense counsel with regards to discovery. I wanted to state on the record, there's no video in the garage that she requested. We're gonna check if there's any other body cam. We don't believe there is. And she also brought up about an appraisal. I think if they want a separate appraisal on the jewelry, they're gonna have to do that at their own expense. And if we don't.
I don't know whether she can hear you where you're at right now. Y'all move to your left.
There's no body cam in the garage for defense counsel request, no security video. We're checking to see if there's any more body cam. We don't believe there is. She mentioned that she wanted an appraisal of the jewelry, a separate appraisal. I think that's something if they want, they'll have to pay for at their own expense. And if this case is not resolved May the 1st, then I'll be ready to get a trial date on May the 8th.
Okay, May the 1st negotiation and the next court appearance is May the 8th. Both of you, okay?
Okay.
You sign it? I can have to check on, no, I can. Yeah, but both of you.
Judge, I have several cases on in Pulaski County on the 8th. Would it be possible to go to your next pretrial conference date and keep that May 1st negotiation?
What do you have in Pulaski County?
I have several pretrial conferences up there, which if I have to, I can do Zoom for Pulaski and come on down there to Clinton County.
Early here, if you want to, then you can head back up there when you do the first thing. Just see what you can work out schedule wise.
Or if she wants to do Zoom, it'll either be a plea or just get the trial date next week.
Yes. Mr. Stockton says he has no objection to you Zoom in here on the May date, on May the 8th. Okay, so you be negotiations May the 1st. If we have a plea on May the 8th, then you can do that by Zoom. If we don't have a plea, then you just have your calendar ready and we can set a trial date. Okay?
Okay. All right. I'll work it out. Thank you, Judge.
Okay.
And that's all I have, if I can be excused.
You raise your right hand. I solemnly swear or affirm that you conduct your duty as a member of the grand jury of the Clinton Circuit Court, that you will faithfully execute that duty and keep all matters confidential for receive the information you have there and protect you from the Constitution of the Commonwealth of the United States. Yes, I thank you very much. And follow the Commonwealth versus Dickin. It says active warrant.
Yes, so he thinks she may be in Ohio.
Yes. You know how.
Active warrant.
You gonna put her in NCIC? Joey Garrett. Joey Garrett. Joey Garrett here? Evidently not. It's motion to forfeit. It's one of Mr. Cross's cases. Is it what forfeit what?
It's cash. It was a 2020 case and there was cash laying around and we didn't know and was asking to be forfeit.
Yeah, how much is involved?
And I think it's less than $1,000. Yes.
Yeah, I'll enter the order.
Okay.
Gary? Commonwealth versus Derek Gary, 25 CR 0015. Are you Derek Gary?
Yes, sir.
Good morning. You born in 1983?
Yes, sir.
Last four digits, social security number 3165.
Yes, sir.
Are you here for a pretrial conference? What does the Commonwealth have to say?
There's not gonna be a plea or we'll need a trial.
He's wanting to hire private counsel.
Well, What happened here? I
Well,
don't
we made an offer. Evidently, he's got a lot of time on probation in Wayne County. He's allegedly down here still in the boat trailer and other things while he's on probation. We offered 5 years. He doesn't want to take it, and he wants private counsel, so I'd say private counsel needs to be here next month so we can set a trial date.
Okay, come here on May the 8th with your attorney. And we'll set a trial date. Like Brian Gross.
I think he's outside.
Brian Gross. Commonwealth versus Brian Gross, 24 CR 0031, and 24 CR 0041. Are you Brian Gross?
Yes, sir.
Born in 1985. Last 4 digits, social security number 2218.
Yeah.
You're on pretrial conference on both of those cases. What is the comment case?
Well, I'm waiting to see what Mr. Gross wants to do. Okay. We can just set,
What are the charges?
he has 2 possession cases and,
What is the offer?
probate. But we'll set 24 CR 31 for trial. That'll be the first trial. There's your point right there. And we can do May the 16th, Judge, if you want to, because Mr. Bourne, he wants to do it for it. That's 24, 31. Yeah.
8/16.
Yes. I'm gonna leave who, I don't give my wife.
Dawson Jarvis. Commonwealth versus Dawson Jarvis, 25 CR 009, 25 CL 0016. Are you Dawson Jarvis?
Yes, sir.
Good morning.
We want
You were born in 2001.
Yeah.
That's what it is, a social security number 7215.
Yeah.
We're on pre-trial conference, explosive Commonwealth episode. Mr. Stockton.
We have a pre-trial version.
Okay. Just being informed that you file a motion to enter a plea today, is that correct?
Yeah.
Are you currently under the influence, are you currently under the influence of drugs or alcohol?
No.
Is this plea freely and voluntarily given?
Yeah.
Are you the same person that we just identified in 25 CR 009 and 25 00016?
Yeah.
Is your judgment impaired today in any way?
No.
Have you discussed this matter with your attorney? Are you satisfied with his advice?
Yeah.
Have you reviewed the evidence Commonwealth has against you, but you're fully informed about this case?
Yeah.
You understand that you do not have to enter a guilty plea. You have certain rights under Kentucky and the United States Constitution. I need to know that you fully understand that.
Yeah.
I'm going to go over them at the end, ask you if you understand it. You have the right not to testify against yourself. No one to make you say anything about the speedy trial, but you're right to be represented by counsel at your jury trial. The right to confront and cross-examine all witnesses called to testify against you. Right to produce evidence, right to call witnesses in favor, right to fill this matter high court if you lose, and right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of charge. Don't you understand that by any guilty plea that you give up all these rights? You understand that?
Yeah.
I may consider the Commonwealth's recommendation, but I may apply a range of sentence for right law. I don't have to accept the recommendation. When you did, I do not accept the Commonwealth's recommendation. You decide to impose a harsher sentence. You have the right to withdraw your plea of guilty and proceed to trial. I'm going to ask you a couple of questions here to see if you're qualified for pre-trial. Have you previously been diverted in the last 5 years?
No,
Have any felonies in the past 10 years?
no,
Are you currently on probation?
no.
Let me understand, if you fully complete the diversion program, the charges would be dismissed, pretrial diverted, and you have your record expunged. You understand that?
Yeah.
Do you understand if you don't complete the diversion, you're brought back before me on a violation, determined you violated, I can schedule, revoke your pretrial diversion, schedule sentencing, and you'll be a convicted felon. I can be used against you in the future. You understand that?
Yeah.
Ms. Gordon Anderson, you want to come forward? You move to your left, sir. Ms. Gordon Anderson.
Yes, Your Honor. Upon a plea of guilty to indictment number 25 CR 9 for the charge of possession of a controlled substance, first degree, first offense, methamphetamine, the defendant shall receive a sentence of 2.5 years. Upon a plea of guilty to indictment number 25 CR 16 for the charge of possession of a controlled substance, first degree, first offense, methamphetamine, the defendant shall receive a sentence of 2.5 years. The 2.5 year sentences shall run consecutively for a total of 5 years. Pretrial diverted for 5 years, supervised. The defendant shall enter and complete the Clinton Specialty Court Program and be released from incarceration the morning of orientation. The defendant shall receive credit for time served. The defendant shall obtain gainful employment or do a minimum of 30 hours of community service per week until gainful employment is obtained. The defendant agrees to have any and all evidence in the above style cases disposed of in a manner that's consistent with laws of the Commonwealth and the holding agency.
Ms. Gordon Anderson, it says in there in your recitation, Ms. Gordon Anderson says in your recitation that you released from custody for that. He's not in custody.
Correct, yes.
He's out on bond. Y'all desire him to be taken into custody until he gets some.
No, Your Honor, I think. Just
Okay, so if you'll
oversight
just,
plea.
if you'll just mark through that. You know, just do that in both of the initials on that. Okay, just that little portion of the custody. Sir, is that your understanding of Commonwealth's recommendation?
Yeah.
Are you pleading guilty because you did commit the act charged in the indictment?
Yeah.
Doing so of your own free will?
Yeah.
And as I said, you understand if you violate pretrial diversion, and I find you that you'll be a convicted felon if they're used against you in the future.
Yeah.
Knowing these constitutional rights and what I've been informed is still your side. Is that your signature on the
Yeah.
document? Accept the agreement. You'll need to meet with the probation and parole officer over there. And do what?
She's standing right there waiting.
Okay, I didn't. Go over meet with the probation parole officer.
Thank you.
Joshua Jones, it says there's an active warrant out for Joshua Jones.
We'll put him in Seattle.
And so he's in rehab.
If that's the one, Mr. Carroll, I'll contact him. So,
Well, but
well, he needs to turn himself in. That's what he's
just issue eventual, is there an active warrant already out? I
Yeah.
have somebody just to serve the warrant. Take it.
When you said that around, Carol Markham call, and the better representing him, he's in rehab.
I don't- Well, somebody needs to go up there and arrest
Sits or,
him. They need to arrest him and bring him in. You cannot put people in rehab and call on your own and say, well, when they get finished, we'll just, maybe they'll come next time. There are arrest warrants out, arrest warrants need to be served, he needs to be processed, he needs to go before the pretrial services, and I'll make a determination on what an appropriate bond, so arrest him. Okay. Thank you for this. I'm not gonna kill the messenger. Tyler Law, LA. For an expungement, is there any objection to that, Mr. Stockton?
No, no.
Okay. Michael Likens,
Mr. Krause's case.
he's the one that was in a physical rehab facility, he had surgery. And he'd been moved out of
I
hospital.
knew he was the last time we was in court. He had something wrong with him, and then when I spoke with Mr. Krause, he said, I'm gonna have to get up with him and find out what his situation is. I would ask for a warrant that Mr. Krause can furnish proof he was physically unable to be here, we can withdraw. Or we can, issue one
you're
later.
sitting in for Mr. Cross, aren't you?
He never mentioned that name, but he mentioned 2 names, and that's all, Your Honor.
Also, they called in.
Who did?
They called, it's that Michael Cross is supposed to be passed. Until it's done.
We're talking about Michael Likens. We,
Yeah, he was supposed to be here last night, you can see.
I thought with Mr. Cross's absence, we wouldn't have any disturbances, but
It's kind of like a Christmas carol.
yeah, it keeps on giving, doesn't it? Could you try to call Mr. Cross and
Your Honor.
tell him aloha and find out what the story on Michael Likens is? Okay? Zachary Markham.
It's
Markham.
Oh, okay, yeah.
Are you Michael Likens?
Oh.
No, you're Zachary Markham, excuse me. You're glad right now that you're right. Commonwealth versus Zachary Markham, 25 CR 0011. Were you born in 2006, Mr. Markham?
Yes,
Last four digits, social security number 8525.
yes,
There for pretrial conference for him.
it's pre-trial version.
Is this a pretrial diversion? Ms. Gordon Anderson, are you in charge of pretrial diversions? The motion has been tendered, sir, that says you wish to enter, that you stay behind the podium here. You stay behind the podium. A motion has been tendered that says you wish to enter a pretrial diversion today. Is that correct? Are you currently under the influence of drugs or alcohol?
No.
Is this plea freely and voluntarily given? Quit bouncing that thing around. Okay. Are you the same person named in indictment 25 CR 0011?
Yes.
Is your judgment impaired today in any way?
No.
Are you nervous?
You know, man.
Okay, just calm down. This too shall pass, okay? Have you discussed this matter with your attorney? Are you satisfied with his advice?
Yes.
Have you reviewed the evidence the Commonwealth has against you?
Yeah.
You believe you're fully informed about your case?
Yeah.
You understand you do not have to enter a guilty plea today. You have certain rights under Kentucky and United States Constitution. Before I can accept a guilty plea, I need to know that you fully understand these rights. You have a right not to testify against yourself. I want you to make the same thing. Right to speed trial by jury, right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses called to testify against you. Right to produce evidence, right to call witnesses to your favor, right to appeal this matter to a higher court if you lose, and right to apply the Commonwealth to prove beyond a reasonable doubt that you're guilty of charge against you. Understand that by entering a plea today, you give up all those rights. You understand that? I may consider the Commonwealth's recommendation, but I may apply a range of sentence provided by law. I, in the event, do not accept the Commonwealth's recommendation and decide to impose a harsher sentence. You have the right to withdraw your plea. You understand that?
Yes.
I'm going to ask you a couple of qualifying questions concerning qualification for diversion. Have you been previously diverted in the last 5 years? Have you felons in the past 10 years?
No.
Are you currently on probation?
No.
You understand that if you successfully complete the program, the diversion program, the charge will be dismissed pre-trial diverted. You understand if you don't successfully complete diversion, you come in front of me and I avoid the pre-trial diversion, or a pre-sentence investigation report, you'll be sentenced to be a felon and that can be used against you in the future. You understand that?
Yes.
To enhance sentences. What is the, you move to your left now, what is the Commonwealth's recommendation?
Upon a plea of guilty to assault third degree, the defendant shall receive a sentence of 5 years, pretrial diverted for 5 years, supervised. The defendant shall enter and complete the Clinton Specialty Court Program. The defendant shall write an apology letter to Officer Kenneth Johnson as regards to his actions on the date of the offense. The apology letter shall be provided to the Commonwealth's officer prior to the entry of plea. The defendant shall receive credit for time served. The defendant shall obtain gainful employment or do a minimum of 30 hours of community service per week until gainful employment is obtained. Defendant agrees to have any and all evidence in the above style cases disposed of in a manner that's consistent with the laws of the Commonwealth and the holding agency.
Is that your understanding, sir? Are you making this plea because you did commit the acts charged in the indictment as amended?
Yes.
Are you doing so of your own free will because you are guilty for no other reason?
Yes.
Where your constitutional rights are extended, explain to us, still your desire to proceed and allow me to fix punishment in the range permitted by law. Is that your signature on the motion and offer?
Yes.
I accept the agreement, sign the diversion order. Now, what did the court cost in this case?
155.
$155. Some time to pay that?
Hmm.
You need some time to pay the diversion order?
I came tomorrow.
Do what?
I came tomorrow.
Well, I'll spread it out over some time if you need some time.
That's fine.
Well, you can pay by tomorrow. I'll sign the diversion agreement. You need to do the probation and parole. Has he been voted into drug court yet?
Yes.
Have you done through the orientation yet?
Yeah, I went yesterday, my
Okay,
very.
good.
He was assessed yesterday by Mr. Kraus.
Okay, well, Mr. Cross will tell you when the orientation is, and I'll leave you out on bond until then. Okay? Dale Morris, did you please just? Both of these. Commonwealth versus Dale Morris. Are you Dale Morris?
Yes, sir.
Good morning. It's 25 CR 0019. Mr. Morris, were you born in 1982? What are the last 4 digits of social security number?
2944.
What?
2944.
2944. Do you have an attorney?
No.
Why is that?
I was told that there would be an attorney presented to
Who
me.
told you that?
Everybody talked to at the jail. I called the courthouse. They told me up there that there would be. They
Does
said,
this go through district court? Did this case go through district court?
I'm not sure what it did.
Well, have you seen another judge? One of them's an older guy and one of them's a woman.
No, I haven't seen another one.
That's for you, Judge Lawson. Watching this.
It's a flagrant non-support, so it.
Flagrant unsupported, well, it still needs counsel.
Yeah.
I'm gonna appoint the Office of Public Advocacy and let them fill out a form to see if you're eligible.
Thank you.
You know, we'll just, as soon as he finishes, here we go. Yeah, I might assess a fee when we get an attorney. Commonwealth does not provide attorneys for people unless they're indigent.
Okay.
How much child support did you owe related to Mr. Stockton? Could you give me an indictment? Could y'all give me the indictment?
It was, right now it's around $3,500.
Yeah, Morris. You have the right to remain silent. Grand jury of Clinton County has returned an indictment charging you with flagrant non-support being more than $1,000. It's just actually they have 3,511.78 as kind of an indictment. Do you understand those charges, what the charges are? You acknowledge the identity of your client received indictment, way formal reading and arraignment, including not guilty, reserving all pretrial motions.
Yes, Your Honor.
A negotiation that will be set up on May the 1st, and the next court appearance will be on May the 8th. You're still on the same conditions of your bond. To make arrangements to talk to your attorney.
Thank you, Your Honor.
Destin Posey. Destin Posey. Commonwealth versus Destin Posey, 25 CR 0014. Are you Destin Posey?
Yes, sir.
You born in 2004?
Yes, sir.
Last 4 digits of social security number 0575.
Yeah.
You have for pretrial conference. What does Commonwealth have to say?
We had pretrial diversion.
I'm just informed that you've been informed that you wish to enter a plea today. Is that correct?
Yeah.
Are you currently under the influence of drugs or alcohol?
No, sir.
Or is this plea freely and voluntarily entered?
Yeah.
Okay. Are you the same person we just identified by social security number and date of birth?
Yes, sir.
Is your judgment impaired to go in any way? Have you, do what?
I said, yeah.
No, your judgment impaired means that you don't know what's going on.
Oh, I'm sorry. I couldn't really hear.
Yeah, impaired, IMPAIRED. Have you discussed the charges with your attorney and you're satisfied with his advice?
Yes, sir.
Have you reviewed the evidence the Commonwealth has against you and you believe you're fully informed about the case?
Yes.
You understand that you do not have to enter a guilty plea, and you have certain rights under the Kentucky and United States Constitution. I need to know that you fully understand those rights before I accept your plea.
Okay.
I'm gonna go down through them at the end, ask if you understand, okay? You have a right not to testify against yourself, no one can make the same thing, right to speak trial, but jury, right to be represented by counsel at the jury trial. The right to confront and cross-examine all witnesses called to testify against you. The right to produce evidence, the right to call witnesses in your favor, the right to appeal this matter to higher court if you lose, the right to call the Commonwealth to prove beyond a reasonable doubt that you give a charge against you. Understand that by hearing guilty plea that you give up all those rights. You understand that?
Yes,
I
sir.
may consider the Commonwealth's recommendation, but I may upon the range of sentence provided law, I don't have to accept the recommendation. In the event that I do not accept the recommendation, decide to impose a harsher sentence, you have the right to withdraw your plea of guilty and proceed to trial. Now, I'm gonna ask you some questions. Have you previously been diverted in the last 5 years?
No,
Any felonies in the past 2 years?
no,
Are you on probation, Chris?
yes, sir.
On probation?
In district court. Yeah, it's different from,
What are the charges?
it's, is it going in danger?
That's, I have to deal with, one endangerment with, he was intoxicated with the child at home. But then we,
That won't prevent y'all from doing a pre-trial. But y'all aware of
Yeah.
that?
I'm not sure if Mr. Stockton was.
Yeah, I didn't see anything that disqualified on this court. That's the only thing I knew about.
Okay. You understand if you complete diversion successfully, the charges will be dismissed pre-trial, the verdict, you have your record expunged. You understand that?
yes, sir.
Do you understand that if you don't complete it, you brought back before me and I find out that you violated, I can revoke your pre-trial diversion, you could be, the pre-sentence investigation report, you'd be a convicted felon. That can be used against you in the future, you understand that?
Yes, sir.
Step to your left, please. What's the Commonwealth's recommendation, Ms. Gordon Anderson?
Upon a plea of guilty to torture of a dog or cat, the defendant shall receive a sentence of 3 years, pre-trial diverted for 5 years supervised. The defendant shall pay restitution in the amount of $1,500 at a monthly rate of $100 with first payment due on May 10th, 2025, and be dispersed in accordance with the restitution order. The defendant shall write a letter of apology to the minor children of Josh and Brandy Renewal, and provided to the Commonwealth prior to the entry of said plea. The defendant shall apologize to the victim as regards to his demeanor towards her, and on the day of the offense, the defendant shall have no contact with the victims. The defendant shall receive credit for time served. The defendant shall obtain gainful employment or do a minimum of 30 hours of community service per week until gainful employment is obtained. The defendant agrees to have any and all evidence in the above style cases disposed of in a manner that's consistent with the laws of the Commonwealth and the holding agency.
Is that your understanding of the Commonwealth's recommendation?
Yes, sir.
Are you pleading guilty because you did commit the acts charged in the indictment?
Yes, sir.
What did you do? Tell me what you did.
I shot a dog for coming on the property, killing chickens. And, well, I went to the house and I told them about it, and they put in a complaint.
He made it go.
That's the allegation.
That's what.
That's what was said, yeah.
You baited the dog to come on his property and shot it. Kill the dog?
Yeah,
Okay, are you making this plea freely and voluntarily? You know your constitutional rights exist still your desire to give up those rights in a plea of guilty and allow the court to fix your punishment in a range permitted by law.
yes, sir.
Okay, is that your signature on the motion?
Yes, sir.
I'll accept the pre-trial version. What was the court cost?
$165.
And what were the payments he's supposed to make? Was this restitution or rest of it?
yeah, yeah.
How much was that?
$100.
How much the total amount?
$1,500.
This dog was worth $1,500.
Golden Doodle, I believe.
Okay, I'm gonna add $25 a month to court costs. What's the total court cost?
Will cost me $155.
So pay an additional $25 a month till you pay that, okay?
Okay.
Meet with the probation parole officer over there.
Okay. They just new statutes.
Stephen Posey. Stephen Posey says there's a warrant out for him. Mr. Stockton, what do you know about Stephen?
That's correct. We'll put him in the asset.
She also has a probation warrant out of another county.
Okay. Emily Savage. Russell County, if you're on there, we'll be with you in just a minute. Commonwealth versus Emily Savage. Are you Emily Savage?
Yeah.
Good morning. Were you born in 2006?
Yeah.
Last four digits, social security number 7828. You're on a pretrial conference. What's the Commonwealth have to say?
We had a diversion plea.
Your Honor, I still need to go over the plea with her and have her sign it.
No, we'll drop it in the docket thing. Scotty Spear. For sentencing. Commonwealth, Kentucky versus Scotty Spear. 24 CR 0088. You are Scotty Spear.
Yes, sir.
You're here today for sentencing. Have you had an opportunity to look at the precinct's investigation report? On the probation parole?
Yes, sir.
The information substantially correct? Is it substantially correct? What's the name?
Yes, sir.
Is there any reason this should not be sentenced?
Nothing I'm aware of, Your Honor.
I'll plead guilty to possession of controlled substance first degree. Third or greater offense, defendant shall receive a sentence of 3 years probation for 3 years supervised. He shall remain in the current treatment facility and complete the treatment of what treatment facility is your client in?
The rest of the coverage.
Mr. Stockton
Yes, sir.
says he shall remain in the current treatment facility to complete the treatment. We should be under probation and parole.
Yes.
What kind of,
He's got another case, he's already being supervised by probation and parole while he's at truth. And this will just be added on to his current probation.
how long is that treatment to be?
It's 6 months, but I like about a month left.
Okay, we make sure you give all the information. What's the court cost this?
155,
One what?
55,
6
155.
155. When you get out of rehab, you take 30 days after that, you make your first payment of $30.
I'll notify his officer also, Judge.
$30 a month after you get out of that rehab, okay?
Yes, sir.
You,
You know what? Thank you.
Thank you, Your Honor.
yes.
Judge, also on the Likens matter, I have called Mr. Cross and not been able to reach him, and I've sent him a text message and have not received a response, so I'm not sure what to tell the board about that.
Well, we'll wait till the end of the docket. See what the deal is. I don't know. Nathan Stockton. Nathan Stockton. 25 CR 0022 Commonwealth, Kentucky versus Nathan Stockton. Are you Nathan Stockton? You born in 1991?
Yes, sir.
Last four digits of social security, you know, 5920. Yes, for the purpose of arraignment, you have an attorney.
Well, he's on vacation. We're hiring him next week. It's
You're on vacation. Who is your attorney?
Stephen Poindexter. He's in St. Thompson.
Yeah. I'll ask the public advocate to stand in for the purpose of arraignment. Mr. Stockton, how come all these private attorneys are on in Hawaii or St. John or somewhere, you and the public advocates are here grinding away?
Somebody's got to work.
Same thing.
Been there all day.
Well, okay, you have a right to remain silent. Grand jury of Clinton County has returned an indictment charging you with theft or deception. You understand what that charge is?
Yes, sir.
I'm signing a reciprocal discovery order that will allow your attorney to receive information from the Commonwealth Department provided. You'll be here for negotiation day on May the 1st at 9 a.m. And your next date is May the 8th. Get both of them are conditioned to your bond, okay?
Okay.
Stacy Stockton. Commonwealth versus Stacy Stockton, 25 CR 0021. Are you Stacy Stockton?
My last name's actually Guffy.
Okay, you want to amend the indictment? Mr. Stockton?
Yes, Your Honor.
Amend the indictment. Were you born in 1993?
Yes.
Last four digits, social security number 0103. You have an attorney today?
No, I'm using the same one. He's on vacation this week.
Well, I'll let the public advocate stand in. You have the right to remain silent, okay? The grand jury of Clinton County has returned an indictment charging you with complicity of theft of deception. You understand what the charge is? Okay. You acknowledge the identity or proceeded that way, formal reading, and you're pleading not guilty, which over the trial maker.
Yes, Your Honor.
No complaints on your bond. I'll allow you to remain free on the same bond. You contact your attorney and be here present for negotiations on May the 1st and May the 8th. Okay? Thank you very much. Wesley Stockton. Wesley Stockton, there you go. Commonwealth versus Wesley Stockton, 24 CR 0088. Are you Wesley Stockton?
Yes, sir.
Good morning. You were born in 1984.
Yes, sir.
Last four digits, social security number 4085.
Yes, sir.
You're here for a pretrial conference in 24 CR 0086.
Based on what Mr. Rutherford only issued, we need one more pre-trial negotiation.
Negotiation day on May the 1st, your next court hearing is on May the 8th. Thank you. Richard Thompson. Commonwealth versus Richard Thompson. Are you Richard Thompson? Were you born in 1976?
Yes, sir.
Last four digits are social security number 1479.
Yes, sir.
You're here to be arraigned. You have a right to remain silent. You're represented by counsel. The grand jury of Clinton County has returned an indictment charging you with improper illumination, possession of controlled substance,
He hired you.
possession of substance in the first degree, possession of marijuana, trafficking of controlled substance in the first degree, possession of drug paraphernalia, and operating a motor vehicle under the influence. You understand those charges?
Yes, sir.
You acknowledge the identity of your client receiving indictment, way formal reading and arraignment, and therefore you're not guilty of reserving all pretrial motions.
Yes, Your Honor.
Signing a reciprocal discovery order here requires the Commonwealth to provide your attorney with information to prepare for your case. Be here on a negotiation day of May 1st and the next court appearance on May the 8th. Okay?
Your Honor.
If bond conditions, I know about curfew in place. So you have a curfew in place.
Yeah. Your bond conditions, you're not supposed to be anywhere but work, your house, church, or the document. You understand?
Yeah, and Your Honor, I just want to make clear that I'm standing in for CD Point Extra on this one. He didn't tell me about Richard, but he's the, you hired him.
Yeah. Okay. That's good. So you'll be here on the 1st and the 8th.
May the 1st.
May the 1st and the 8th. You write that down?
Yeah.
We might have May the 1st at 9 a.m. for negotiation. Maybe David Towery. Commonwealth versus David Towery. 25 CR 0012. Are you David Towery?
Yes, Your Honor.
Good morning. And you were born in 1998.
Yes, sir.
Last four digits, social security number 9388.
Yes,
I'm here for a pre-trial conference. What's the Commonwealth have to say?
Have a pre-trial diversion, but
I've just been informed that you have a motion to enter a guilty plea today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea free and voluntarily given?
Yes, sir.
Are you the same person that we just identified in 25 CR 0012?
Yes, sir.
Is your judgment impaired in any way today?
No, sir.
Have you discussed these matters with your attorney, and are you satisfied with his advice?
Yes, sir.
Have you viewed the evidence the Commonwealth has against you, but you're fully informed about your case?
Yes, sir.
You understand that you do not have to enter a guilty plea, that you have certain rights under the Kentucky and the United States Constitution. Before I can accept the plea, I need to know that you understand those rights. You have a right not to testify against yourself, no one can make the same thing, right to speak in front of a jury, right to be represented by counsel to your trial, right to confront, cross-examine all witnesses, call, testify against you. Right to use evidence, right to call witnesses, and if you right to appeal this matter of a higher court if you lose. Right to part of the Commonwealth, prove on a reasonable doubt that you're guilty of charge against you, understand that by any guilty plea, that you waive and give up all those rights, you understand that?
Yes, sir.
I may consider Commonwealth's recommendation, but I may find it in sentence, but I don't have to accept the recommendation. In the event I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea guilty and proceed to trial. And I want to ask you some qualifying questions. Have you previously been diverted in the last 5 years?
No, sir.
Do you have any felonies in the past 10 years?
No, sir.
Are you currently on probation?
Yes, sir. It's 2 years unsupervised in Wayne County.
For what?
Shoplifting.
Is it is it district court?
It's misdemeanor. I saw, I remember right there.
Okay. You understand if you fully complete the diversion program, the charges will be dismissed? But if something you can tell.
No, I did not speak with him about something different about that.
Step away from the podium and talk to me.
We're good, Your Honor.
You understand if you're not fully completed or successfully completed, you're brought back in front of me for a violation. I found it to be violating the terms. I could revoke your pretrial diversion or the pre-sentence investigation report. You'd be a convicted felon that could be used against you in the future. You understand that?
Yes, sir.
What is the Commonwealth's recommendation? You step to the left there. What is the Commonwealth's recommendation?
Yes, Your Honor. Upon a plea of guilty to operating a motor vehicle with alcohol concentration of or above 0.08 or while under the influence of alcohol or other substances, first offense, the defendant shall pay a $200 fine and cost. Upon a plea of guilty to possession of a controlled substance, first degree, first offense, methamphetamine, the defendant shall receive a sentence of 3 years, pre-trial diverted for 5 years supervised. The defendant shall receive credit for time served. The defendant shall obtain gainful employment or do a minimum of 30 hours of community service per week until gainful employment is obtained. The defendant agrees to have any and all evidence in the above style cases disposed of in a manner that's consistent with the laws of the Commonwealth and the holding agency.
Is that what you agreed to?
Yes, sir.
And you know, the DUI is enhanceable too. If you get more, and the DUI, it's more serious.
I'm aware, sir.
Okay. Are you entering a guilty plea here because you did commit the acts charged in the indictment?
Yes, sir.
Okay, you plead doing so of your own free will?
Yes, sir.
I will accept that you have knowingly accept the statement that knowingly waived your constitutional rights. And you've agreed to allow the court to fix your punishment. Is that your signature on the motion and offer?
Yes, sir.
Okay, I'll accept and sign the diversion order. Counsel, has he finished all his DUI paperwork that he has to do?
Yes, he has.
It's been filed with the clerk's office.
It's right there.
Okay. You need to meet with the probation parole officer right here. And was there somebody we passed over that changed their mind here?
Jimmy Corner. Emily Savage.
I just need to know the paperwork with that stuff.
Okay, go ahead and go over it with Mr. Porter.
Then we've got,
Is there anybody else here that's scheduled?
Mr. Morris, to see if he was wanting to ever do the rain. Was he qualified?
We finished the review.
Oh, okay, I missed him.
What about Larry Thompson?
We had Emily Savage.
Judge, there is Jay Phelps at RCDC.
We hadn't got,
Yeah.
we're just in person. Is there anybody else here in person? I didn't mark off Emily Savage. Did we do her?
No, he's that store.
Well, is there anybody else? I thought there was somebody.
Jimmy Corner. So we got two police.
Where is, he's back there with Pointer too, so he's back there with Emily Savage and Pointer.
If we could take up the Phelps in Russell County Jail, then Mr. Strack and I could discuss the Cumberland.
That'd be good. Russell County Detention Center, you turn your camera on. Okay, first is Corey Bard, sentencing. They've got them lined up there. There's just two more. for you.
105B, please.
Are you Corey Bard?
Yes, sir.
You born in 1993?
Yes, sir.
Last four digits, social security number 0642.
Yes, sir.
Sentencing in 24 CR 0028 and 24 CR 0039. Would you bring the public defender back out here? Bring the public defender back out. I should have known, should have done that case like you suggested. That was really easy. Who was the person that had a private counsel? It's okay. I'm just for sentencing on Corey Bard. Mr. Bard, your attorney's here now. Have you had an opportunity to go with the pre-sentence investigation report done by probation parole?
Yes.
Is it substantially correct?
Yes, sir.
Is there a reason someone should not be sentenced?
No, Your Honor.
Pleaded guilty on indictment number 0039 to be charged with escape second degree persistent felony. Y'all are keying that mic there if you don't mind, okay? The defendant should receive a sentence of 10 years on pleaded guilty on 0028 arson third degree. He should receive 10 years. The 10-year sentence in 39 and the 10-year sentence in 28 will run concurrently, however. For 10 years, probated for 5 years, supervised, he shall receive credit for time served of 401 days. Shall be released in sentencing incarceration upon sentence. He should be, what are the court costs in this case?
155.
155, sir, we'll release you today. You have your first payment of $30 toward your $155 of the court costs within 30 days. When do you want him to come in probation parole office?
Is he already currently on, aren't you on probation, Corey?
Yes.
Who's your officer?
I don't know. I'm on the revocation for it in Wayne County. I gotta go to Wayne County after I leave here.
So you still have a holder?
Yeah.
Okay. As soon as you get released, report straight to the Monticello Probation and Parole Office.
All right. Thank you.
Okay. You know, who's your client that you had? You have
Jerry Phelps, done for sentencing.
J. Reed Phelps. I'm gonna call J. Reed Phelps now.
We'll have to get him last. He's got to be brought out separately.
Okay, well, let's just wait then. Let's go with John Bombard. John Bombard.
They have gone to get him. We have Hicks and Tweedy ready.
Their attorney is not ready. He's back in the back. So the reason I was trying to,
Yes, Your Honor.
he's going over with some other clients. Well, can you clear the area? At Bombard, you said you had to bring out separate.
Bombard is on his way up here now. We have to bring Phelps out separate.
Okay.
They're ready for you.
No, I didn't.
They're ready for you.
Hello?
We're waiting for your attorney to come back in. He stepped out of the courtroom, okay?
Yes, sir.
You are John Bombard.
Yes, sir.
You're on 25 CR 0023. You have the right to remain silent. Your attorney will be present in just a second. Were you born in 1967, sir?
Yes, sir.
Last four digits, social security number 5834.
Yes, sir.
Counsel, you come out here just for a second. We'll give you plenty of time to do them after you. This is John Bombard. He's here for arraignment. I've informed him that he has the right to remain silent. The grand jury of Clinton County has returned 2 charges against you, charging you with wanton endangerment of the first degree. You understand what the charges are? I'm not asking whether you did it or not, but you understand what the charges are.
Yes, sir.
Counsel, you acknowledge the identity of your client received indictment, waive formal reading, and plead not guilty, reserving all pretrial motions.
Yes, Your Honor.
And we'll schedule negotiation day on May the 1st. The next court appearance on May the 8th. Now, I'm not familiar with the case that knows what are the bond conditions here.
It is $10,000 cash.
What's the charge?
It's wanting in danger for discharge of the firearm. I will tell the court, I've got two juvenile witnesses that are giving inconsistent statements, so it might be appropriate to set a smaller bond.
I can't hear you, I'm sorry.
It's wanting endangerment, first degree discharge of the firearm. And allegedly, Mr. Baumgartner was shooting a gun in the neighborhood. But I've got two juvenile witnesses that are giving inconsistent statements about what they saw or heard, so a lower
What's his
bond would probably
bond
be appropriate.
set? Can you have somebody come in and make make an unsecured bond for you? It just means they'll come in and say they're worth $10,000 and they sign a bond, it won't cost them anything. Can you hear me, Mr. Barnard?
Sir?
Do you have anybody that can sign, right now you have a $10,000 cash. You
Yes,
haven't been
sir.
able to make that. If I allow somebody to have a clerk approved surety bond, you have somebody that can come in and sign it.
Yes, my stepmom, she was out there in the hallway waiting.
And what's your stepmom's name?
Judy Hannemeyer.
I will approve her. She'll come in and sign a $10,000 surety bond. You're to stay away from the people that were involved around in the shooting. You're not to have any firearms or anything until we get this resolved. Do you understand that?
Yes, sir, I do.
You'll be here on May the 1st for negotiation and May the 8th for the next court appearance. And we'll all send a release for you as soon as she signs the bond, okay?
Yes, sir. Thank you very much.
Thank you. Now, who else we have here? Candace Tweedy. We're finished for you, Mr. Barnard. I guess we got Bobby Hicks. Who do you have? Oh, it's Candace Tweedy. Commonwealth worth is Candace Tweedy, 23 CR 0058. Are you Candace Tweedy?
Yes, sir.
Born in 1997.
Yes.
Last four digits, social security number 2464.
Yes, sir.
Sentence, and you get an opportunity to look at the pre-sentence investigation report under probation and parole.
Yes.
It's substantially correct.
Yes.
On May 13th of 2024, your pretrial diversion was granted and it was voided on February 6, 2024. Therefore, is there any reason why she shouldn't be sentenced?
And no, Your Honor.
Yes, you shall be sentenced to 3 years. Okay. Thank you very much.
Thank you.
Thank you.
Yeah, thank you. Who do we have? You have, who do you have, who was it they had bring out by himself, shall we? Okay, do you have Bobby Hicks available? Commonwealth versus Bobby Hicks, 23 CR 0017. Are you Bobby Hicks?
He's struggling to hear, so you may have to speak up.
Are you Bobby Hicks? Mr. Hicks, can you hear me?
Looks like he's asleep.
This is Bobby Hicks.
Well, he's gonna have to hear me before I can take any action on the probation revocation.
Okay, he's wrote out that he can't hear you and he can't speak.
I guess we need a transport order for next month, Your Honor, so we can.
Okay, we'll transport him, or transport order, have him here on May the 8th.
Yes, Your Honor.
Okay. Now, the only one you have left now is Jairee Phelps. Is that correct?
Yes, sir. I'll go get him.
Thank you so much. Yeah.
The sex offender for Mr. Phelps, he's already signed it. You just have to read it to him and sign.
Thank you.
Yeah. No, don't be judgmental.
Here's the financial statement. July. We're ready for Jarvis Phelps. We're finished with Mr. Hicks. Whoever.
Down there, have your name.
Are you Jarvis Phelps?
Yes.
This is 24 CR 0027. You're here today for sentencing.
Yep.
This is, were you born in 1993?
Yes, sir.
Last four digits of social security number 4673.
Yes.
Have you had an opportunity to look at the pre-sentence investigation report?
Yes.
The jury recommended 45 years to serve. There also here is the registration form and the sex offender registration notification. I see where you've signed those. That is your signature on there? Good. Make sure I sign these. I can sign them now. Counselor, your client says he's reviewed the pre-sentence investigation report. Is there any reason why he shouldn't be sentenced today?
There is not, Your Honor.
Okay. I sentenced you to a recommended time of 45 years that the jury gave you, and I will sign these registration forms for sex offender, okay? Thank you very much.
Yep.
And is that all y'all have over there in Russell County?
Yes, Your Honor.
Thank you for your cooperation. Y'all may be excused. Y'all have something you want to bring up about? Is that a
Yes,
Cumberland County
we have a
case?
motion to suppress that's scheduled for April 11th, Mark 10 a.m. One of the Kentucky State Police officers is unavailable. I think I need his testimony as regards to the waiver and consent to search. So we're asking it to be moved to April the 24th. I don't think Mr. Strack has any objection.
I do not, Your Honor.
Okay, we'll reschedule, cancel and reschedule.
What time do you want it set?
What, this call the name of the case, so
Commonwealth versus Brandon, Posey, 24 CR 50, Commonwealth Circuit.
is that a rule day?
At the rule day on the 24th, if the court wants to have a different date.
No, it's okay. We'll just have it in the docket.
Okay, is that all right?
Sure. You say
About 11 o'clock.
11 o'clock Central?
Into the criminal docket.
Yeah,
Yes.
we'll just set it for 11.
I can do that.
Thank you.
Thank you, gentlemen. Thank you, Your Honor.
Thank you. Okay, let's go to Clinton County Jail. I guess we have a couple of people here we're still waiting
We
on.
might as well just wait for Mr. Buster to get to me.
Okay, well, right now would be a good time to take a break. The public defender is not available right now. We'll take a short break for the calls here. Let's go off the record. All right. Mr. Ramsey, y'all, you have some more cross things today?
I'm handling a civil thing for him this afternoon in addition to a civil case that I have on. No, no, no. I will be back this afternoon, Judge.
We have to have a clerk. Clayton County Jail, turn your camera on.
Yes, sir.
We're ready for Jason Craig.
Sorry, I get him right now. Jason Craig. Here he is, Your Honor.
Are you Jason Craig?
Sir,
You're on 25 CR 0020. Mr. Craig, were you born in 1978?
sir.
Last four digits, social security number 7123. You're here for arraignment. You don't have an attorney. I look at your affidavit. Why is it that you're not working anywhere? So,
Sir, I've been a student for the last 8 months. I just completed a 6 month work ready peer sport certification through Miller College. I actually was going to ask you about that today. You could adjust my bond because
I'm not talking about your bond yet, sir. I'm asking you, why don't you have a job?
Well, I was supposed to, that was part of my certificate that I just earned. I was supposed to have a job at the end of that. However, I relapsed, sir, and that job you had to have a year clean. So I made a decision for my advisor.
I'll appoint a public advocate for you.
Thank you.
The public defender is here. Mr. Craig, you're here for the purpose of arraignment. You have a right to remain silent. Your attorney is standing here. He should wave at your card.
Hey, Mr. Craig.
The grand jury of Clinton County has returned an indictment charging with fleeing or evading police to first degree, operating a motor vehicle under the influence, operating under the influence, aggravating circumstance, possession of controlled substance, possession of controlled substance, first degree, prohibited use of license, possession of controlled substance not in the original container, failure to maintain insurance, and being a persistent felony offender. You understand what those charges are? You understand what those charges are, sir?
Yes, sir.
Counselor, you acknowledge the identity of your client, proceed indictment, waive formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions.
Yes, Your Honor.
So negotiation day on May the 1st and the next court date on May the 8th.
And if we could address his bond, I don't know if.
I'm not going to address his bond.
Okay.
You just got appointed. You don't know anything about it, do you?
No.
Or you go down and interview and talk to the Commonwealth. And then with some information, y'all talk to each other and contact me, okay?
Right. Thank you.
Thank you. Richard Ferguson.
Thank you, Judge.
Richard Ferguson. Commonwealth versus Richard Ferguson. Are you Richard Ferguson? Are you Richard Ferguson?
Yes.
You're here today on 25 CR 0010 for a pretrial conference. You born in 1968, sir?
Yes.
Last four digits, social security number 0521.
Yes.
What does the Commonwealth have to say?
We have a pretrial diversion plea on.
A motion has been tendered, says you wish to enter a plea deal. Is that correct? Is that correct?
Yes.
Okay, something's wrong with the microphone down there. Y'all need to turn it up. Something's wrong with it.
Can you hear me now?
I can, but you shouldn't have to yell that way to hear. Are you currently under the influence of drugs or alcohol?
No.
Is this plea freely and voluntarily given?
Yes.
Are you the same person named in indictment number 25 CR 00010? You the same person that's in that indictment?
You might need to hold the microphone.
No, is there somebody in the jail there? Somebody in the jail, will you check the microphone?
Can you hear me now, Your Honor?
Turn it up a little bit more. Now somebody say something.
About now, Your Honor.
Okay, that's a little better. Is your judgment impaired today in any way?
No.
Okay. Have you discussed this matter with your attorney? Are you satisfied with his advice?
Yes.
Have you reviewed the evidence the Commonwealth has against you? Believe you're fully informed about your case?
Yes.
You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky and the United States Constitution. Before I can accept a plea, I need to know that you understand those rights. I'm gonna go over them at the end. I'm gonna ask you if you understand them, okay? You have a right not to testify against yourself. No one can make the same thing. Right to speedy trial by jury. Right to be represented by counsel at your jury trial. The right to confronting, cross-examine all witnesses called to testify against you. Right to produce evidence. Right to call witnesses in your favor. Right to appeal this matter to higher court if you lose. And right to provide a Commonwealth to prove beyond a reasonable doubt that you're guilty of charge against you. Understand that about entering a plea guilty today, you give up all those rights. You understand that?
Yes.
Now, I may consider the Commonwealth's recommendation, but I may apply the range of sentence provided law. I don't have to accept the recommendation. Prior to accepting the recommendation, this is a pretrial version. That's the wrong sentence. I'm going to ask you to answer some questions to see if you're qualified. Have you previously been diverted in the last 5 years? Have you had a pretrial diversion in the last 5 years?
No.
Any felonies in the past 10 years?
No.
You're currently on probation?
No.
You understand if you successfully complete this pretrial diversion, your charges will be dismissed and you can have your record expunged. You understand that?
Yes.
You understand that if you don't successfully complete the program or they charge you having to be brought back in front of me, and if I avoid your pretrial diversion, I order a pre-sentence investigation, you'll be a convicted felon and that could be used against you in the future. You understand that?
Yes.
What is the Commonwealth's recommendation?
Your Honor, he will agree to plead guilty with criminal possession of a forged instrument, second degree, receive a sentence of 3 years to serve. That 3-year sentence is to run consecutive to the diversion he just entered in the last Cumberland County Circuit case, which make a total of 6 years, be pretrial diverted for 5 years. He agrees to complete the specialty court program and pay $100 restitution within 60 days. One of these cases should have been transferred to Clinton or Cumberland so that we could have done the plea together, but it's oversight on our part. So I think we're doing them contemporaneously.
Is that what you agreed to, sir?
Yes.
Are you pleading guilty because you did commit the acts charged in the indictments?
Yes.
Do so of your own free will?
Yes.
Know your constitutional rights, extend your desire to proceed with your guilty plea and allow the court to fix your punishment. You have the agreement here.
I don't have the agreement, Your Honor.
Who has the agreement, the signed agreement?
We don't have it. I'm not one to look at blank, I'm not signing anything.
I turned in all the copy I had to Cumberland, over in Cumberland County.
You did sign the agreement for Cumberland and Clinton County, is that right, sir?
Yes.
And what we'll do is we'll just call them and have them email you or send you a copy to the file, okay? Now, what was the agreement on the court costs over there? Remember? We'll look it up. I'm gonna merge the court costs or waive the court costs here.
Thank you.
And let them pay the one court costs. When did Mr. Ferguson get out?
Well, I just spoke to Mr. Kraus, he said Monday or Tuesday, that he's covering for Mr. Gray this week, so it'll be Friday.
Because they'll do your orientation at the beginning of this coming week for drug court. When they do that, I'll sign an order. If they said it'll be Monday or Tuesday, I'll let you out, okay? Okay, thank you very much. Jamie Harold.
Jamie. Jamie. It's a second, Your Honor, I get it.
Just go ahead and get on these Comtock's riding always. I don't need all 4 days.
Commonwealth versus Jamie Harold. Good morning, Mr. Harold. This is 24 CR 0081. You were born in 1977. The last 4 digits, Social Security number 3525. Is that correct? Have you had an opportunity to look at the pre-sentence investigation report done by Probation Pro? Is it substantially correct? Counselor, is there any reason that gentleman should not be sentenced?
No, Your Honor.
Defendant, upon plea of guilty possession of a handgun by convicted felon, defendant should receive 5 years, serve 180 days with a balanced probate for 5 years supervised. The defendant agrees to pay restitution amount of $500 at a rate of $25 a month plus what's the court cost? $155 is a court cost, and I'll allow you to pay that at $30 a month also. So the total that you need to pay a month would be $55 a month, okay? You understand that? Okay. When does he need to meet with Probation Pro?
Judge, he's only served 75 days, so I will get with him before he
Okay,
releases.
you got about 100 days left. As soon as that happens, you make these payments 30 days after you're released. Okay, 30 days after you're released, and Probation Pro will be down to meet with you. Okay, thank you very much.
David, can I talk to you for a second?
Pardon?
I've got walker pneumonia. I was wondering if there's any way I could get a few days to get out to where I go to the hospital, house arrest or something, just to get to the hospital, get my health problem took care of.
Have the jail, you know, I've already sentenced you, and I don't really have any control over you anymore. What's about the Department of Corrections? Let me have one of the jailers come forward.
Yes, sir, Your Honor.
He's a state prisoner as soon as I sign this.
No,
He's probated, okay.
he will get a pen.
You what?
He'll get a pen for the remainder of his
He'll be a
alternative
state
sentence.
prisoner.
Yes.
Yeah, with a pen. So, what can y'all do about medical?
They will transfer him to Russell County and they'll take care of it there.
Okay, when will y'all transfer him to Russell County?
Today, if you're getting sentenced and stuff.
Okay, well, it'll be signed. Will you inform them at Russell County about this special, that they need to have him looked at by a doctor?
Sure.
Okay, thank you very much. Dennis Kempton. Dennis Kempton.
Yes, sir, Your Honor, I get it.
Y'all are picking up on the recorder. Y'all are picking up on the recorder. Sorry. This one, G.
JC, I'm talking about the wrong place.
This is a motion to revoke probation. He's got a 5-year sentence.
He's not here. You don't have it.
Yes.
You're picking up on the recorder.
YouTube, they'll know what's going on.
Commonwealth versus Dennis Kempton, 23 CR 0060. Are you Dennis Kempton? Okay, I can't hear what he's saying again down there.
Yes, Your Honor.
There's something wrong with your volume down there.
Can you hear me now?
Okay, Mr. Kempton, this is 23 CR 0060. Were you born in 1974?
Yes, Your Honor. Yes.
Yeah. The last four digits, social security number 8161.
Yes, Your Honor.
From probation revocation, Mr. Stockton, what do you have?
Your Honor, Mr. Kempton has a 5-year sentence on burglary third. He was supposed to report February the 27th. He didn't report. The officer made numerous different times of attempts trying to find him. An arrest warrant was issued, and he was arrested on March the 8th. And he also didn't go to IOP like he was supposed to.
Y'all want to stipulate?
Well, Commonwealth agreed to it. He'd be having good rehab as opposed to. You know,
We can have a hearing if we need to, but that's not.
Are you going to stipulate to the violations and then we can
Yes,
talk
sir.
about what's going to happen?
Yes, sir.
Stipulate the violations. What's the Commonwealth's recommendation?
According to Mr. Payne was, he just won't report. That's the problem. And he didn't go to IOP, so it's either rehab or revocation. And I don't know if he'd stay in rehab. If he's in rehab, that's kind of where I'm.
Okay, well, I'm going to order him to a long-term rehab, 6 months. I'm not going to send you to penitentiary. You know, but I'm going to order him to rehab, and if he leaves the rehab, he shall immediately report to the Clinton County Jail. Okay?
Y'all gonna do it, but.
I'm not going to revoke your probation. I'm going to put you in rehab. You stay in the rehab and do what they want to, Mr. Kempton, and you can avoid the penitentiary. If you leave that rehab for any reason, report to the Clinton County Jail immediately. You understand what I'm saying?
Yes,
There's
Your Honor.
not going to be more of you're not complying. You're not in control of this situation. You need to do as you're told to do in this. You understand that?
Yes, Your Honor.
Okay, thank you. John Maynard. Commonwealth versus John Maynard, 23 CR 0043. Are you John Maynard?
Yes, sir.
Good morning. Were you born in 1962?
Yes, sir.
Last four digits, social security number 0138. You're here for sentencing. Have you had an opportunity to look at the pre-sentence investigation report done with probation and parole? Is it substantially correct?
Yes.
Counselor? Is there any reason this gentleman should not be sentenced?
No, Your Honor.
Upon plead guilty to traffic and controlled substance, first degree, first offense, the defendant shall receive 5 years. He shall receive credit for time served on plea of guilty to operating a motor vehicle under the influence. The defendant shall receive 4 days. The 5 years and 4 days shall run concurrently for a total of 5 years. What are the court costs in this case?
$820.
$820, and I'll allow you to pay that at $50 a month, 30 days after your release.
And Your Honor, he has some pretty significant medical issues going on. So maybe just let the jail know that he's being transferred to.
They're going to take you to Russell County, and when they do the intake up in Russell County, you need to inform them that the judge told you, tell them what medical issues that you have. I don't want to go over it online here in respect for your privacy. Okay, I don't want to discuss what kind of medical problems, but those guys, you guys at the jail, we also inform this gentleman needs a close examination to see what his problems are, okay?
Yes, sir, Your Honor.
Okay, thank you very much. James McIntosh.
Just a minute, Your Honor.
Are you James McIntosh?
Yes, Your Honor.
We're on 24 CR 009. Mr. McIntosh, were you born in 1962? Last four digits, social security number 3474. We're here on a pretrial conference. What does the Commonwealth have to say?
Your Honor, we're scheduled for a trial next Wednesday. And also I filed a 404B that detailed another incident with a minor where Mr. McIntosh allegedly drew a gun on them when he was being delivered food from Junction Station.
Get behind the podium.
So I filed a 404B on that. That case is being presented to the grand jury today. So I didn't know if Mr. McIntosh wanted just to try both of them next Wednesday, or if he wants a separate trial. I'll do whatever he wishes.
Well, is this a separate incident?
Well, this is what happened. On June the 28th of 24, a young juvenile, I ain't gonna mention his name, went to Mr. McIntosh's residence to deliver food. Mr. McIntosh had a gun, shotgun. He was shooting it around. He was saying things. I'm not gonna repeat what he said. And as he was shooting, he went around to load the gun, the shotgun, and while he was loading it, he was pointing the shotgun at the juvenile. The juvenile went back to the old Junction Station, reported it. They put him on a do not deliver list. So that's the case that's been presented to the grand jury today when he pointed the gun at the juvenile that time. Then he used a separate address, a different address on July, I think it's the 14th, one's case we're trying next week. Young man went to that address and went to the different address. And at that time on their do not deliver list, they just put the address down. They didn't put the person. So went to that address. This is the case where he allegedly put the handgun toward the young man's head. And we're trying, that's the case that's set for next Wednesday. So
Let's just try it next Wednesday. I don't see how you can try both of them.
Okay.
Well, I agree to that.
Try them
It's
separately.
the other bad act. He's gonna 404B him on it. You'd rather try both of them or would you try one of them?
I would like to, if I could, wait to see what the grand jury does with that.
Well, I'll tell you what the grand jury will do. They're gonna indict him.
Yeah.
So I haven't been down there, but I don't know of anybody that doesn't get indicted. If there's not a presentation about a firearm pointed at a child, so you can go ahead and let's just pretend you already know what they're going to do. Let's speculate, just do some probability here.
But I don't know. I'll do either way. I'll try.
Well, what do you want to do?
I think it'd be best at the same time.
Okay, we'll try both of them next week then.
I'm gonna have the same witness.
Okay, same witnesses, okay. Okay, your attorney will be over to see you, Mr. McIntosh. Ryan Nally.
Yeah.
Commonwealth versus Ryan Nally. Are you Ryan Nally? Were you born in 1982? With their last four digits, social security number 5190? Is that right? We're here on 22 CR 0014 for probation revocation. Mr. Stockton, you want to tell your story about Ryan Nally?
Yes, Mr. Nally has 10 years on a burglary second in T-Butt. And he absconded basically, in January of this year, he failed to report to his probation department in Indiana. He had been at the Lighthouse program in Kentucky for 2 days for treatment and left. Then when he didn't report to Indiana, they asked for him to be revoked under ICOTS. I think, is that right, Mr. Payne? So that's the situation. And we can't send him back to, I think it's Illinois or Indiana. I'm sorry, Indiana. They won't take him back at this point.
Yeah, and he's willing to relocate back to Kentucky and then enter in some rehabilitation program.
So it's either that or both.
Well, what you want to stipulate to the charges and talk about what's going to happen to you?
Yes, sir.
Yeah, if Mr. Rutherford can find him a place, a long-term facility in Kentucky, then he can establish a resident.
Tell me about the underlying charge.
This is the case, Mr. Nally was the cooperating witness when we tried Steve Bridgman on the arson case, on the house that was burnt down toward Lake Kermit. And he served quite a bit of time. I think he served close to a year in jail before he was probated and then he testified at the trial.
Well, I'll do a long-term treatment. We'll do a long-term treatment. Now, listen to me, Mr. Nally. You don't have to be compliant. You just can't be pulling these decisions. We'll get you in a long-term treatment facility. If you leave that treatment facility, you immediately report to the Clinton County Jail. You hear me? Okay, thank you very much. Daniel Norris.
Yes. Yes.
Commonwealth versus Daniel Norris. 24 CR 0029, 30, and 40, as well as 46. Are you Daniel Norris?
Yes.
You were born in 1996?
Yes.
That's 4 digits, social security number 1043. Tell me about this, Mr. Stockton.
Mr. Norris has a 15-year sentence. He has an escape. He had various theft and burglary charges where he was breaking into the tobacco shop down here. We entered a plea where he served about a year in jail, I think, didn't he?
Yes, yeah.
And we entered the plea so he could pay restitution and be on probation. He reported once, I think, and paid one payment of restitution. Then he didn't show up in March. He was listed as absconder, and we got a warrant of arrest. So he's missed, I think that's right.
So. Yeah, Mr. Norris, then struggling, I think with some mental health issues.
You stipulate to the violations of things.
It's either a revocation if he's having a mental health problem. Maybe he can find him a dual diagnosis place to go to. Other than that, but.
How much money does he owe this people?
Oh, it's quite a bit. Could you look it up, Mr. Thrasher? I think you should probably find it quicker.
Think about it. It's over $30,000.
Around $30,000 because of them. Yeah, you start selling a carton of cigarettes, it don't take long to add up.
Was he working there?
No, he actually broke into the place twice. They got him the second time on the security video.
$24,371.76.
Yeah, I knew it was way up there.
That's one case. He has 2 cases.
Yeah, I think there's another one about 3,000 or something. I don't see any hope for the victim to ever get monetary compensation in this case. And his family, they pay the rest of it.
$4,060.70.
So it's close to 30. Yeah.
Because you just failed to report one time.
Well, he missed his report day. Then he talked to family. They said, we'll get him in another day. He didn't come in, went out to his house, left a contact notice, wouldn't answer his phone. It was a process. It wasn't just one time.
You care if I inquire of your client?
Yes, that's fine.
Mr. Norris?
Yes.
Can you hear me?
I hear you.
Okay, are you capable of getting a job?
Yeah.
Well, what's the deal with you? I'm about to send you to the penitentiary for all these things just because you won't report in. If you report into probation and parole and let them work with you, you can stay a free man. You understand that?
Yeah.
Why did you do that? Why didn't you report in?
I wasn't supposed to.
Well, that's not right. When do I'm going to give you one more shot at this thing so you can stay out and try to pay these people back for all that tobacco.
I think that's the problem, Your Honor, because of the mental health issues, he thinks he doesn't have to report.
Yes, I think
From what Mr. Payne and I discussed.
Well, what do y'all have a process for an evaluation for someone that's on this?
No, I sent him for an evaluation, but he absconded right before he completed it.
Yeah.
I think as part of his probation, probably needs some type of mental health treatment. I didn't know it at the time that would have been part of the plea.
He did, because right here's an order of competency.
Yeah, we had him sent to KCPC.
They found him to be competent.
Yeah. What's?
They found him
I
competent.
believe he's gotten significantly worse since that time, from my limited interactions with him.
Okay, he is, and one of the other ones.
Well,
I'm worried with the diagnosis.
how about, in other words, if I find somebody, Mr. Payne, if I find somebody has mental issues that keeps them from complying with my order of probation, you all have a process where they can be evaluated?
We can set them up with mental health counseling, but that's all that we can, that's the only option we have. We don't have, we can set them up, we've got a few avenues we can set them up with.
Well, if I revoke him and send him to the penitentiary, what are y'all gonna do with him?
More than likely, he will end up at one of the mental facilities and they'll be able to, they will work with him.
I think that's the best option, is to revoke him, send him to the mental facility. You track him and I'll take a look at shock probation.
Okay, I understand.
We're gonna send you somewhere, Mr. Norris, to try to get you some help. And then my goal would be to get him out after he gets some help and let him get to work and pay this off. Okay?
It may need, deal with the shop.
Yeah, I'm gonna revoke his probation and take a look at shock probation. Thanks a lot, Mr. Norris. They'll try to get you somewhere to get you some help. Larry Thompson.
That's just a reason.
I'm appointing the Office of Public Advocacy to represent Mr. Thompson. I'm sorry. Are you Larry Thompson?
Yes, sir.
You're here for the purpose of arraignment. Your attorney is here. You have the right to remain silent. The grand jury of Clinton County has returned an indictment charging you with burglary in the second degree or complicity of receiving stolen property or complicity of in theft by lawful taking or disposition. You understand what the charges are?
Yes, sir.
We're also charging you with being a persistent felony offender for all three of those charges. You acknowledge the identity of your client, receive indictment, waive formal reading and arraignment, enter plea not guilty, reserving all pretrial motions.
Yes, Your Honor.
Signing reciprocal discovery order here in this case. And scheduling a negotiation day on May 1st. Your next court date is May the 8th. Jamison Wallace, your attorney will be up forward to see you, Mr. Thompson, okay?
I'll see you soon.
Yes, sir.
Jamison Wallace. Are you Jamison Wallace?
Yes, sir.
This is 23 CR 0013. Review of probation violation. Were you born in 2003?
Sir.
Last four digits, social security number 1655.
Sir.
And what does the Commonwealth have to say?
Yeah, I don't think I filed a motion on this. What happened was we got the violation report in and Mr. Wallace was charged with assault fourth. And I looked at the allegations on it and we inquired with Mr. Raines' office to see if it could be a felony. And they told us that the victim wasn't going to pursue the matter. And they ended up continuing the case for a year on good behavior. So I never did file that. So I'm willing to let this stand for a sanction. And my understanding was it was he got into it with a friend of his girlfriend's. What I was told, I think the county attorney's office.
Tell me what happened, sir.
I was living at my place and I asked her to leave and she wouldn't leave. And she, was kind of getting upset with me. And my kid was about 3 feet to my left and she was coming at me real aggressive like. And whenever she swung, I didn't have no other choice than,
So you tagged her.
After she, swung on
You
me.
tagged her. If she swung at you, you tagged her. Right?
Yes, sir.
Okay, now, let me tell you something. She just about almost getting you sent to the penitentiary. So there's some people that you cannot have relationships with. They're what you call a toxic relationship. Toxic means poison. You understand that? Now, so you're gonna put yourself at risk if you get involved with her, and y'all can't do any better than trying to tag each other. Doesn't work. Now, is she gonna be back living at your house again?
No, sir.
Yeah.
They have an EPO against each other now.
Okay, well, y'all got these EPOs, and if you violate EPOs, I'll have you back here and send you on, okay?
Yes, sir.
When can you report to your office?
Tomorrow morning.
Okay, I'm gonna let you out in the morning. You go straight to the probation and parole office over in.
He's on that thing. And Judge, his probation ends, he's got 2 months left, 6, 7, and 25.
Well, you think it ought to be extended a little bit?
I'm not, that's up to you, Judge.
I know it's up to me. I'm asking.
Extend it for a,
Well, I don't know. What do you think, Mr. Stockton?
I'd say till the end of the year, man.
Yeah, I'm gonna extend your probationary period through December. Okay, and you go over probation and parole, I'll let you out in the morning here at 8 o'clock and have somebody take you right over there. And they're gonna talk to you. You can't be out knocking around on women or anybody else. You know, if you understand that?
Yes, sir.
Okay, thank you very much.
Thank you.
William York. Mr. York, I'm appointing you an attorney. Why aren't you working for Mr. York?
Do what?
Why are you not working somewhere?
Yes, I am.
Where are you working?
Metalworks.
And you're just making $400 a week?
A little over 400, sir.
What are they paying you now?
15.
I'm gonna have to take down. 6 is.
Okay, I'll appoint you public defender and reserve the obligation to pay till a later date. Okay, you have a right to remain silent. The grand jury of Clinton County has returned an indictment charging you with flagrant non-support. How many children are involved in this? You know, Mr. Scotty. $12,375. You acknowledge the identity of your client, received indictment, waive formal reading and arraignment, enter plea of not guilty, reserve the pre-trial.
Yes, Your Honor.
Your attorney's gonna be over to speak to you about this stuff, Mr. York.
Your Honor, I've had Mr. Yoder in here before on flagrant non-support cases, and I'm gonna have to verify if that's the amount, if that's from my previous case or all of it's on this case. And if he's got a job, is there anything else holding him other than our bond?
Where are you working at, Mr. York?
Metal.
Where?
I think you work with Michael Warner, don't you?
Yes.
Yeah, so
Do we get a wage assignment?
we may,
Plays out.
yeah, and I'd say.
How much a month?
I don't know, I'd have to look at the records, but I can do all that at the pre-trial. I just like him to be out working rather than being in jail.
Well, Mr. York, your Commonwealth attorney has intervened on your behalf, saying and verifying that you're working. We see some very few people that are working people. We're gonna give you a break. You be here on the 1st of May for negotiations, and then the 8th of May for your next court appearance. What kind of a wage assignment do you want? How much?
I'll have to get child support, probably, whatever the current amount is. I think it's in 5 years, maybe even half of them.
I could pay a little extra than what they did for us.
Well, don't volunteer more than you have to do here.
I tell you what he needs to do, when he gets out of jail, he needs to go to the child support office and set one up.
Go to the county attorney's office and set up some payments with them, okay? And then and after you do that, it'll help you on your negotiation day. I'm gonna let you out today. Now, what time do you have to be at work? Can you be at work this afternoon?
Well, I usually work Monday through Thursday. I go in at 5 in the morning till 3, but I'll have to go talk to him. I'm sure he'll let me work.
Well, why don't you go ahead and start working more than that, because you're gonna need the money.
I will, sir.
Okay. I'm gonna let you out today, and I'm gonna let you out on ROR, on his own, ROR. Okay. Mr. Stockton said they couldn't run you off if they wanted to. So you're gonna be able to sign yourself out, go see what you can work. When you're not working, you need to stay at home, the doctor, or church. You understand what I'm saying? You go to work, home, church, until we get this settled. Okay, thank you very much. Is there anyone else we have down there at the Clinton County Correctional Facility?
Should be it, Your Honor.
Okay, y'all are excused. Mr. Stockton, do you have anyone else?
Mr. Larkins.
Oh,
Mr. Lockins?
I think this is correct. I thought, it may be my oversight, but I think I did get a agreed order from Penny Dalton, who's working for Mr. Cross. And I signed it and sent it back to Mr. Cross's office because he hadn't signed it. So I bet you never got the agreed order.
I'm entering it now.
These things come, it's almost, I could write a book on the Kentucky Rules of Evidence, refresh your recollection, because that's what happens to me all the time.
Okay, we'll put him on the docket until May the 8th. Thank you very much.
You haven't showed me that.
That concludes, let's go off the record here. You gonna get me off the record here? You get me off the. Okay. Is everybody here too? 4, 6, 8, 9, 3 short here. So they're on the way. Okay, the grand jury has returned. Who's the foreperson of the grand jury? Madam foreperson, will you stand there? 9 or more of you agree on the documents you have in your hand?
Yes.
Would you present them to the bailiff? Thank you. Ladies and gentlemen, everything seems to be in order here. I've signed the order here. The way the thing operates here, we'll present them to the clerk's office. They'll enter them in the computer. We'll have warrants issued. I'll set bonds on them. If we do warrants, if they're already incarcerated, quite frequently I do summons because there's no reason to have them served again. But the bonds are set after we take a look at their record. When they're arrested or turn themselves in, then they'll be reviewed. The bond conditions that I put on will be reviewed by the pretrial folks to see if I'm in error or they think the bond's sufficient or not sufficient, primarily to assure the people's attendance and or the protection of the public. So it'll be a day or two probably before these are delivered. And so I encourage you to keep confidential the return of any indictment that you have, because people might try to get scarce or something like that. You won't be called back in case of, unless you have a riot or insurrection or a tariff. You might get called back in on tariff, everybody's worried about that. I'm not worried about it, but in all seriousness, you won't have to come back until May the 8th. May the 8th, okay? Thank y'all very much. You're excused and you're off the record. Sure, come on up. Yeah, her funeral is Saturday, 2:00. She's leaving the nursing home up there. Sure. time to start the child support schedule.
You ready? Blank.
Shelton versus Shelton.
Your Honor, there's an agreed order and you have filed that online, is that correct?
We're trying to be followed. Sloan versus Sloan.
The same, Your Honor.
Agreed order signed.
Yes.
Callan versus Fairchild.
That person here.
No.
Okay, this is a motion, Your Honor, to increase based upon wages. We obtained information from Tyson about the increase to $472 a month. Did you talk to them, the person? Oh, Stephanie talked to her and she didn't express an objection to that?
No. We got around, she's already sent the order of.
Okay, so, has the order been submitted?
Yes.
Okay, so we're asking for that to increase based upon the wages.
You submit an order on that? Okay. Carroll versus Blanky, Blank.
That's the person that's here. You can come up, sir. All right. And,
are you Timothy?
Yes, sir.
you have, you acknowledge that there's an arrears to a custodial parent.
Yes.
Is it the case now you're working at McDonald's?
Yeah, started, my first day was yesterday.
Well, that's good. And you provided the information about that to child support worker, correct?
Yes.
And we're asking that you pay $1,000 by May the 7th and then continue to make your payments, and it can be through wages. Do you agree with that?
Yes.
You pay $1,000, that's it.
I should be able to, yeah.
Okay. Okay, well, we'll enter an order and you'll be served on you. Make sure you give them your correct mail address, okay? And don't say it out loud, but step away with her and get, step up what it does.
And the order's been submitted, so you'll get the information.
Okay, thank you, sir. Cabinet versus Dickon.
Is there anyone here for that case? So this person is employed out of town, and did you talk to someone on his behalf?
His ex-wife called.
His ex-wife, what'd she say?
She said he was out of town, but he thought he could pay this $500 by May the 7th.
So you submitted an order to
Yes.
the court electronically for that?
Yes.
So you're requesting that that he pay $500 by May 7th towards his arrearage balance of $89.14.
Yes.
You want, if he doesn't pay it, then you'll hold him in contempt
Yeah.
30 days jail. Okay, that's fine. Cabinet versus Britt.
She just received the worker, did Your Honor, an agreed order, but she hadn't filed it electronically, but here it has been signed by the,
So let her file it one time.
okay. Now, if you have problems filing, just come to my office this afternoon, we'll whip it through.
You know how to do that, though.
Yes, yes.
I think because Michael's not here, having problems getting into the system, is that it?
And I think that's what it's like.
Oh, his password's expired. Well, come to me, I'll help you when I get done with court here. Yep.
Okay, is that it?
I think Harris, is that on the
I
docket?
see it on the document.
Robert's gone, Harris, is that on the docket?
Britt was the last one I had.
Now, what is that?
I don't think she's got anything.
Okay, George, did you have a case with child support or is that a different thing?
It's actually a motion to establish child support, yes.
Okay, did you,
It's
you
on-
were,
I think it's on the civil.
it's on the civil, okay, so you're not aware of it. Okay, that does it, Judge.
Okay, thank you.
Would you like this stuff back? It's up, if you, can you call me this
Yeah,
afternoon?
we're gonna, let's start to 1:30, so let's go off of there.
Okay, thank you.
Okay, let's go back on the record. Smith versus Smith, 25D0006-0001. Sammy Brooke Smith versus James Leonard Smith Jr.
Were they asking for more?
We made an issue here, so I just want. Yes.
Okay, this was scheduled here today and the parties indicate that they had reconciled and wanted dismissed, but they're gonna have to come back in here. I don't do that without the parties appearing, let me eyeball them. See what they do, so continue it to next month and issue a summons for the Smiths to be here at 2:00. Okay, we all want to come forward here? Smith versus Smith. Are you Sammy Brooke Smith? And you are James Leonard Smith Jr.?
Yes, sir.
Now, I looked at the affidavits originally, you made some fairly serious allegations as to what happened. You still stand by those allegations? And you're asking y'all to reconcile with each other.
Yes, sir.
And you're not here under coercion or anything. You want to drop because you want to drop, you think you're safe. And you understand what kind of problems this has caused you, don't you? You think you can refrain from using physical threats or activities against this woman?
Sir.
No matter how she provokes you, no matter what happens, you walk away and you do your best not to provoke you and walk away too. I'll sign the order dismissing the thing. Hopefully have really, there's nothing better that can happen in a relationship than have a true reconciliation. Do y'all have children together?
Yes, sir.
See, it's a blessing for them and I hope you appreciate that and take care of them, okay? So we'll dismiss it. Thank you. Thank you.
Thank you.
If we have an agreed order in Anderson versus Anderson.
No, I don't do read orders today. That's go against everything that's happened today. So. Okay, what's the case number on that?
Is 2534.
Okay, the parties here,
One of them is,
the attorneys are here.
okay,
Okay, tell me what this is about.
Let's see.
Not yet. You tell me a little bit.
This was a motion for exclusive use of control of marital residence, both
Y'all
parties.
reached an agreement about that?
We have, Your Honor.
Okay. Who do you represent?
I represent the wife.
Does she get to use the property now or what?
They're both gonna continue to live there as they have been.
Okay, how's that working out? Okay.
Pretty good, and there's an upstairs area and a downstairs area, so that's a problem, I think it's gonna be
Y'all
okay.
electronically submit that, is that what you want to do? Yeah, if you got it signed, just give it to the bailiff and I'll sign it and we'll electronically file it, okay?
Thank you, Your Honor.
Yeah.
Thank you.
So she meant, she had not said, and she is sick.
Okay, yeah, it appears it's time to go forward. Mid-South Capital Partners, Mid-South Capital Partners versus Charles Winkle and others. Same report. And also a request for a fee. Mr. Ramsey, you're just trying to charge $252.87 for your one order returns thing. And Mr. Cross is wanting to charge $500, and I want to know why your one order efforts are worth less than his. Do you have any reason?
I guess Mr. Cross is just a better warning order attorney.
Maybe he has more overhead.
I won't comment on that.
Yeah. I think on a case like this, at $500 is appropriate for each one of them. So I'll award each one of you 500 if you just submit an order.
Thank you.
Okay, thank you. Yeah. Warner versus Warner. Warner versus Stearns, with John and Betty Warner versus Stearns.
You don't have to stand up here. You can if you wish.
Yeah, they're welcome to. If you move over to this side and be with your clients, Mr. Little, and okay, I've read your motion for judgment notwithstanding the verdict and alternative for the trial. I read this motion. I guess there was a late filed response.
I filed a response yesterday, Your Honor.
That I just reviewed a few seconds ago. I will tell you that the result of this trial was not what I expected. But it was not what I expected for reasons other than are addressed. I'm going to tell you what my concerns are, and I hope it doesn't disqualify me, or maybe I do hope it would disqualify me if this case was tried again. Something that was not argued at the case that much was the deed to the northern piece of property that talked about that easement. And then the purchase of the Warners of that one section there that had no other possible use other than to get access to that right of way. There was no other reason why they would have wanted that little quarter. They said it was for sentimental purposes, but they didn't. You know, the fact of the matter was you couldn't stand a goat on that little piece of land there. So I can't really go against what the jury has done on the instructions that were given, because they made specific findings. And I could see how people could go one way or the other on the issues that were presented, like easement by necessity. I don't think that there was enough proof as far as easement by necessity, because there was testimony about these other areas. Apparent easement, there was testimony about how the place was all grown up. And, you know, you couldn't tell the difference. And what was the quasi easement? You know, I could see how that could go either way. But what I want to ask you, gentlemen here, to go beyond the pleadings of this case, what if the Stearnses came back in and tried to litigate this as far as the easement with other theories of the case? Do you think that this judgment cuts off other theories of the case? I mean, would it be res judicata?
That's my fear. I don't know that it would.
Well, see, that's the dilemma that I'm in. I really believe that they're entitled to an easement by that other deed and the facts of the case where they buy that corner, but not under the instructions that were given. And I think that I'm limited on setting aside the verdict based upon what's in front of me, not on what I think should be. You know, this is a case of law, and I gave every instruction that you asked for every theory that you asked. And at the time, I can't interject myself into the thing and say, well, there's this deed that talks about. I can't see what else that deed would have been talking about other than an easement across other property. And I can see how Mr. Stearns, when he looked at it, would have believed that that would have created an easement across it, but it didn't get it done. I'm not criticizing anybody that did any document, but that document in itself alluded to that. and made it appear that that's what it was. So I could understand how a non-lawyer, even somebody that's like Mr. Stern, just obviously a sophisticated business person that deals in things like that. But I could see how you could read that and think that, you know, and it was even testimony that it was announced at the sale that he felt like that he had easement and nobody challenged it at that situation. But I just, Mr. Little, this is a situation where the verdict surprised me. But with the reasons that I've got, I don't see how I can set that aside. Yeah, what do you say, Mr. about the thing?
As to.
Move over a little bit, don't hog the microphone. Yeah.
As to setting this aside, or as to the 14-foot easement that's alluded to in one of the deeds?
Well, as to whether or not I can set it aside.
Yeah, Judge, I don't think that, as the court said, there was evidence that on all three instructions could have cut either way. And I think if this were a situation where, as a matter of law, no reasonable juror could have found the way that they did, then the case would have been right for a directed verdict at trial, and all those motions were denied on both sides. And also,
well, I could still come back here.
I understand you could. Yes, I understand you could.
In retrospect and say, well, you know.
I understand, but I think the court made the right call at the trial by not granting those. And then also, there's a claim that the jurors violated their oath and they were by passion or prejudice in making their decision. These were unanimous verdicts. And so if that is the argument that's going to be made, then Mr. Little saying that all 12 of those jurors that decided the case and decided it unanimously were all prejudiced in some way against the defendants. So I respect the court's statements and the potentiality of the 14-foot easement. We'd have to deal with that if that came up. But as for this right now, I don't think that there's enough to overturn what the jury has done.
What do you have to say?
Well, my arguments are pretty simple, Judge.
Maybe that's why I understand them so well.
That's good. Yeah. Well, a reasonable person, and we've got the correct standard, in my opinion, could not found as the jury did based upon the simplicity of the instructions. And a lot of these cases are not tried by jury because if you go to the jury instruction handbook, there is none for these cases. There's a lack of instructions in the handbook, so you have to create them from the case.
Well, I've helped in the past write instructions.
Yes, that's right. Well, apparently
he got me overturned in a case, and now we got a new instruction that was the Supreme Court that is the law, but it's still wrong.
It may be. But under apparent easement, how the court or jury was instructed, to find apparent easement, you must be satisfied by the evidence that both parties purchased their property with knowledge whether actual constructed that the path claimed by the defendants existed. So
isn't that what the law is?
That was the instruction.
Was that what the law is?
Yes.
Okay.
We cited the law in the motion.
You did, and I gave you every instruction you asked for.
Right.
And that one would have been an instruction I think you were really entitled to. There's no doubt about it. I think it was properly made. It could have gone either way. Now we'll go to your next instruction.
Well, I want to make an argument about that one, of course.
I thought you already had, excuse me.
Well, I'll make a written argument, but the oral argument would be before even the defendant put on his defense, the plaintiff himself admitted that the easement existed or that roadway existed. It was created in approximately 1968. And a smaller piece was purchased in 1973 by Joe Warner to use that for access to the larger piece. So apparent easement, I don't see how a reasonable jury could not find apparent easement.
Well, there was testimony that was all grown up and you couldn't find the road and that sort of stuff. I mean, that testimony was there.
There was no evidence of that regarding the part that went through by the road. Because the video showed it. It was cleared. It was no growth there. It was a well-worn path.
I'm talking about over the piece of property. That's what we're talking about. We're not talking about the little quarter-acre section that you go over the hills. That's what you're talking about.
I'm talking about, where he would have to go through.
Yeah, where you'd have to go over the hill to get down across the creek.
Correct.
I listened to it very closely. I mean, I understand. That's the reason you got the instruction. I gave you the instruction.
Right.
Then go to the next instruction.
Quasi easement. The findings would be the properties and parties had a common owner. That was admitted. Joe Warner was owner of those pieces. We introduced the deeds. There was a separation of title from the common owner, resulting in one tract being owned by the plaintiffs, one tract being owned by the defendants. That was the master commissioner sale in 2021.
That's correct.
That was established. That before the separation occurred, the passageway in question for so long continued, obvious and manifest, it must have been intended to be a permanent passageway. Okay. The evidence was from the plaintiff, his father had purchased this smaller piece to serve the larger piece and used it since 1968 with permission and into 273. And if the mail went around the house all the way, there's a mailbox there, used this passway.
Well, I never did understand how the road around the house had anything to do with this easement. The road around the house wasn't down on the piece of property where the easement was going across. The house, obviously, I can see it in my mind. The house sits here. There's a little road this way, and then there's this 1/4 acre place to the right off the road where you go down that way. And so going around that house didn't have anything to do with using that other easement down there, Mr. Rowe.
Well, it was using that access also. That's part of the same case because that driveway supposedly is on part of it.
Well, they didn't know that until this lawsuit happened, because they'd always thought that going around the house went with the house, and they ended up finding out that it doesn't.
Right. Yeah, and that's why we had to present to a jury so they could see it. And they saw it.
And I think it's pretty obvious, but that would only give them an easement around the house. It wouldn't go down into the bottom land down there. The problem is getting it out of that bottom land down there. That's the problem. And I don't see how that evidence gets them down there. And what's your third thing?
Well, the other thing was the use of the passageways was highly convenient and beneficial to the land conveyed to the defendants, which is the larger piece. So the evidence was, and Mr. Warner admitted it, that the smaller piece was purchased to serve access to the larger piece. That was the whole reason for it being purchased.
I don't remember him testifying.
It's in the record, I believe he did.
That was the sole reason that it was purchased. The testimony that I heard about it was at the sale, Mr. Stearns had offered the Warners the opportunity to buy it all if there was a sentimental value to it. And once they got finished, the Warners got finished bidding with other bidders, then Mr. Stearns asked to be released from that and started bidding on it himself. But then he came back and that for whatever reason, and I think this was a mistake, that the master commissioner had listed that 1/4 acre as a separate piece of property when it should have been in the entirety. We wouldn't be here today if that 1/4 acre hadn't been sold separately. You would agree to that?
Or if it was purchased together.
Well, it couldn't be purchased together unless it was sold together, because Mr. Stearns had the opportunity to buy the little 1/4 acre for next to nothing, but he again offered as an accommodation to the Warners to allow them to have that if it had some sentimental value to it. And so he deferred to them and they bought it, and then they shut it off.
Right, I agree with that.
Okay, so which the question is whether you think that was a nice thing to do or the right thing to do or whatever. So I gave that instruction because I thought that it could go either way, and the jury found against you on that instruction. So I gave the instruction. What's your third?
Well, the third one was the easement by necessity, but I think
that's the weakest argument.
That's the weakest. So I'm sticking with the first two. Under quasi easement, I believe there was enough evidence that a reasonable person could not have ruled as the jury did, because the testimony was that it's been used for 50 years or longer to access the larger piece. There was no contrary evidence. That's why everybody was surprised that at least the court officials, I was surprised by how the jury ruled because of how the strength of the evidence was. And matter of fact, the only surveyor used was Greg Talbot, and that was the surveyor for the defendants. There's no contrary evidence.
But he testified that he couldn't see any evidence of any road down there, didn't he? Did he testify?
The upper portion, not the lower portion.
You're talking about the upper portion.
Correct.
He was testifying down on the property. So he was testifying.
Well, on this part, it's all.
Well, I don't know what you're calling the upper or lower. The upper is what you're talking about next to the house. Is that right?
No, next to Charlie, is what I call the upper, with the property he
The
already
upper
owns.
is the one that one of the sisters sold.
Correct.
Okay, that's what you're calling the upper.
Right.
And the lower part, you're talking about where the house and then going over the hill.
Yes, yes. But that's my argument, is a reasonable person could not have ruled that way based upon all this evidence.
But, you know, now, talk about the portion about the prejudice in your.
Well, that's just a part of the argument, being a reasonable person cannot rule that way. They spent less than, well, I think about 10 minutes in making their verdict, which would not be enough time to review, in my opinion, the photographs and the deeds and even the jury instructions and come to a.
Well, I will admit that it took me longer to read the instructions than it did for them to decide, but they might have been carefully listening when I read the instructions and understood them. What do you have to say, Mr.
Your Honor, as far as the time it took to reach the verdict, you know, that's to the jury, and I have no reason to believe that they were not listening during the trial. I mean, we tried this over a day and part of a second day. I think that they had all listened to the evidence, and when they got back there, more than likely, just discussed how they felt, and they came out unanimous. I mean, again, Judge, you've kind of alluded to everything that I would say regarding the evidence that was presented at the trial and the basis that the jury could use in reaching the verdict that they reached.
What? And it doesn't really have anything to do with my decision here, but what would it take to, the lowest level of access to this property that would allow these people to be neighbors again? What would it take? I mean, obviously the Warners don't want to open up a piece of a lane up through the middle of their land. And obviously, Mr. Stearns wants access from this end of his property. He's got access from the other end, but there's a creek down there that's a problem. What would it take? Have you ever discussed your property?
I think we have, all I can think of is a gate that both parties could access. The only purpose of the gate would be to keep other people who don't have any business down there out. And
Well,
allow.
is there another route? I remember there was testimony about another route over the hill back, if you're looking at the house to the left of the property.
It wouldn't allow access to his property, because the testimony was some of it's inaccessible otherwise. That's where the easement by necessity instruction came in.
Well, you know, that's the reason that you got that, but the jury said it didn't agree with that.
I understand that you asked about what would.
Yeah, well, I'm just trying to say, you know.
That's my opinion.
Yeah, well.
Judge, if I may.
Yeah.
I've thought of two potential resolutions on this.
Okay.
One of which would probably be the less likely, but if the defendants didn't want the lower portion and were willing to work out a deal where they sold the lower portion to my clients, I don't know how likely that is on either side. The second thing, which Mr. Little and I have discussed some, would be a gate across the property. I think my clients would be desirous of, if there was a gate situation, only Mr. and Mrs. Stearns here having access, and for notice to be given to my clients when they plan to use it.
Well, what would be the deal if they ever sold the property? Mr. Stearns looks like he's a healthy man. I hope he lives a long time.
Yeah.
You know, but what if at some point in his life he becomes where you can't get down there and take care of it? He wants to sell it. Would that run with the property, that whoever got the property would have to call whoever owns it later and get permission? Now, I wonder how those last down through, you know, I mean.
It could either be an easement that goes with the land, or an easement in gross that's just with the Stearnses, and then that would have to be taken up again with any future owners. But for now, I've just been trying to.
I would think they would have to go with the property rather than the easement in gross, because that would do that. Have y'all talked about that recently? Has anybody talked about that recently? Mr. Little, would you be willing to sit down and talk about that? Here's what I'm saying. I don't think it's beyond the realm of possibility that this case could be overturned. I don't think it's beyond the realm of possibility. I don't think it will happen. I don't think I have enough to overturn it. But just out of a kind of a sense of justice and access to property and things like that. Now, this happens to be people that all have lived here. Well, my experience now is that we have all these people that move in here. And the first thing they do is put a fence up and close somebody off because they say, well, I looked in my deed and there's no easement in my deed. And they don't take into account all the arguments that Mr. Little has rightfully made about the different kinds of easements and that sort of thing. Then the other thing that bothers me about these cases like this is in the case that I alluded to previously, the Supreme Court ruled that if you give somebody permission to go across your land and you die, and there was someone standing there when you gave permission for them to cross their land, that person, your grandson or whoever was there, you can't testify that permission was given because it would be hearsay. It's not like the tradition of boundaries and things that we always able to get in. What did the community think or that sort of thing? So we're dealing with that. That's the reason I want to know what kind of easement, because if you went in by permission, then the Warners later on, even if they gave permission, you know, the subsequent owners of this land will say, I didn't know anything about any permission that was given. We used it all that time, and the subsequent owners might not know about the permission or might want to get a lawyer to say, well, you don't have to rely upon that because nobody can testify you gave the permission. So we're in a dicey sort of thing. So I would like for y'all, after hearing what I've said about it, and I will tell you this, and I don't mean to insult you, okay? But the kind of business you're in, I didn't really know. I've known you as when you were a politician and you've been around places that I was in. I always had a good relationship, I felt like. But I didn't know what kind of business you're in, and people that inspect property and plumber inspectors and things like that don't make a lot of friends, you know, and that there could have been something on that jury like that somebody didn't, but that's mere speculation on my part. And it doesn't take but one or two people because juries are odd situations, but I'm concerned about the short amount of time that the jury was out also. I'm concerned about that, but my concern about it can't overcome the fact that they might have been closely listening to the thing all the time and got back there. So I'd like to ask y'all to go back there if it's not too bad and talk about possible resolutions to the thing before I make my final ruling on it. Okay?
Your Honor, if I could, the only thing that gives me a little bit of pause today, Mr. Warner couldn't be here because he is sick, and I think that certainly he would like to have.
He would need to be present.
He would need to be present.
Okay, I'll take this under advisement and I'll enter a ruling in 10 days. Is that fair? You think Mr. Warner will feel better, or we don't know? Is it serious? I hope it's not serious.
I'm sure he'll be better.
Okay, well, I think it's only fair, and you're up here standing up for your family, like Ms. Turner's standing up for her family, and that's good. People need to do, but I'd like for y'all to try to get together and see what we can do. Because there is uncertainty how this thing would end up in the appellate court. And the other thing about the appellate court is there won't be a resolution in the Court of Appeals, and then the Supreme Court will get a chance to look at it. Okay, well, thank y'all for the way you've conducted yourself today. Okay,
Thank you, Your Honor.
Thank you very much.
Jarvis, you'll go to my office. I'll check that.
There's the next case, David Cross versus York. Now, David Cross is an assignee of Bluegrass Cellular Inc. is the plaintiff in this case. Okay, tell me about this case.
Your Honor, my understanding of the case is that Mr. Cross purchased a judgment lien that was attached to this property and has filed to foreclose on that and for sale of it. It's my understanding from him that no answers have been filed, and he is asking for a judgment order of sale, and he is going to tender the judgment if the court so orders.
Yeah, ma'am, could you identify yourself?
Lord,
Get up here. And you're one of the
I'm the only one.
yeah. Well, obviously, if you're Laura York, you don't have any unknown heirs there because you're still with us, right? They're one of the parties here, the unknown heirs. And who was Bobby York?
My husband, but we've been divorced there since last year and separated ever since 2013.
Well, did he own some interest in this property?
It went in my name.
It's a divorce, you got it in a divorce?
Yes, but it never went in his name. No way.
Well, I'm not asking you whose name it went into because he could have a marital interest in it. See that you don't understand, but you got the property in the divorce, is that right?
Mhm.
It's non-marital property.
I couldn't speak to the judge.
Yeah, I'm not trying to know.
Gary Little was my lawyer.
Yeah. How much is this lien for?
Your Honor, I
You
really
get
don't
the
know
file
the
out.
answer to
Is the
that.
file in here? Is this the file? See what this lien is for.
Mr. Cross did tell me that there could be some questions as to who's entitled to receive any of the proceeds from a sale of this, but he believed that it was right for a judgment and order of sale based on the plea.
Well,
It was $1,984.28 at 18% interest in March 9th, 2009.
oh, jeez. How much interest?
18%.
18% interest.
And I'm not sure what who the original holder of the lien was. It's my understanding Mr. Cross purchased the lien.
Did you do business with Bluegrass Cellular? And you owed them a bill and they sued you for it? And they got a judgment and then they put a lien on this, judgment lien on this property.
Right.
And it's been running up at 18% a year since 6 years. Well, 18% at 16 years would probably take it around $5,000. When you think that would be?
What year was it? 2019, so it's been 6 years.
Yeah.
1,800.
It compounds.
Yeah, it probably is $4,000 to $5,000.
Or maybe two. Okay, now, is there any way you can pay, if this is your home, is it?
We've not been there in a long time, since
Yeah.
13.
So, it would be First National Bank, has he got an interest in it?
Yes, Judge, I think there is possibly a life tenant that's involved, but the property was still allowed to be mortgaged. And I'm not sure who the life tenant is versus who the remainder interest is.
Who is it? Who has the life estate?
Well, it's my mother. I don't know. I thought they signed it, everything over to me, so that's all I know. Barbara Daniel, that's it. I don't. She just put a stipulation in there, so I know.
First and foremost, has one Velocity Investments, has one City of Albany, has one
Clinton County.
County, has one. It says that there is a priority of conveyance from Charlotte, Arlington, to the school, given Barbara Daniel.
Who is Barbara Daniel?
That's my mother. And that's my sister, the other one.
How big a piece of property is this?
It's on Second Street, right behind where the old library used to be. Go down to there, just right across from Steve Burchett. It's not real big. It's got a house and you got a little bit of land on both sides. Well, on one side and then in the front. There's really nothing on the other side. It was Elmore's on the other side connected to us.
Well, unfortunately, I'm gonna have to enter a judgment on the thing because you did not file a response to the thing, and he's entitled to default judgment. I don't know, the master commissioner will advertise, and then there'll be a determination on these liens that have been filed on it, who gets the first lien. Okay, now usually the city and the county, which means that the property taxes have not been paid for some period of time.
No, the property tax has been paid on them.
Well, the city or the county has some claim on it. It might be for current year.
I've been paying them, that's all.
Well, I don't know what it is, but somebody's got the city or county. So I'm gonna have to sign the order and let the master commissioner, what do you think the property's worth? Do you have any idea?
I don't know. It's in the city limits.
I guess we could go find out what it's worth, because of that lien. So,
It's in city limits. I don't know.
okay, well, thank you very much for calling, and the master commissioner will be in contact with you, and they'll advertise the property. And then you'll have an opportunity, if you want to lawyer up, or if you want to get somebody to come in and argue how much of this, if anything's left after these liens are done, how much of it is yours? How old is your mother now?
76, about to be 77.
Well, that doesn't seem as old to me as it did at one time. But she has some sort of life estate, and her life estate won't be worth that much that would be set aside to her if she hadn't signed it over to you. But the master commissioner will look into all that for you, and find out who has it, okay? Okay, well, thank you very much for coming.
Thank you, Your Honor.
Yeah, and you have Mr. Cross to submit the judgment,
Yes.
or you could.
Maybe I'll file one and assert an attorney fee.
Okay.
Yes.
Denny versus Denny. Denny versus Crawl. Okay, what's your motion?
Our motion is to establish child support obligation. This case originated in Russell County and family court over there. An order was entered transferring the case here to Clinton.
You're Jerry Haywood Denny?
Sir.
And you have the children?
Yes, sir.
One child or two children?
Two.
And who is Emily Crawley, the biological mother or
Grandmother.
biological grandmother? Is Kendra Dakota Denny? Is Kendra Dakota the one that called in and said she was 2.5 hours away? And is she represented by counsel? Does she have a lawyer?
No, she's never had one before. Her mother, which is Emily,
Yeah.
who previously had joint custody while she was away. She had an attorney, but she's not participated since.
Okay. Well, you're gonna let the child support officer calculate child support.
We went to the child support office, Your Honor, he did, and they were the opinion that the prior transfer order would not allow them to proceed with the child support modification at this time, but the prior order indicated that either party could seek child support in the future. So that was specifically reserved to do that. So I guess they did not.
If I order the child support office to calculate the child support.
Okay.
Is there anything, where's the previous order that you're talking about? Rick, you get the language with you?
Yes, it would be,
If they have a family court over there, and I always usually defer to these family courts.
well, the transfer order, Your Honor, was just recently entered, but the agreed order that was entered in the case that was incorporated in that transfer order. It says, paragraph 1, this is entered July 27th of 2023. And paragraph 1, the agreed order said respondent fathers will have joint custody of the children with petitioner mother, the father being designated primary residential parent. Neither party shall pay monetary child support at this time, but either may submit that question to the court for resolution by filing a proper motion for same. Neither party owes the other child support arrears at this time.
Okay. And you want like child support based on minimum wage?
Yes, we've imputed that, attached a chart, calculated.
Saw that.
Minimum wage comes out to be $302.
And how many children are there? How old are they?
10, 7.
Does she visit the children at all?
Occasionally, yes, sir.
Yeah. Let's submit me an order.
Thank you. Excuse your honor.
Yeah, absolutely. Claiborne versus Catherine.
Your Honor, this is a case in which Mr. Cross day before yesterday, filed a motion to continue. My client is Marcus Riddle. He's associated with Laura Claiborne. He was a minor when this all started. He's an adult now.
And this is your motion?
It is.
What kind of relief did you want?
This is regarding, my client just turned 18 in January. He had a child with a minor. They were both minors. The child is almost about 18 months old. And he's never got to see the child. Her parents won't allow it. And he has filed a motion for joint custody and to get a time sharing schedule. He understands that it needs to be probably gradual because he's never met the child.
So who has custody of the child?
The mother is a minor, but her mother.
She lived with her mother?
Yes, her mother is Leslie Catron. And Leslie Catron is the one that applied for child support.
Did the cabinet start this originally?
They did. My client went and had a DNA test done immediately after the child was born. And then
Mr. Cross is involved in this case?
he is, yes.
Well, let's reschedule this case until May the 8th. He's out of long-standing situation. And so he represents the biological minor mother
Yes,
and the grandparents.
yes, he does.
The grandparents have any legal authority as far as the child is concerned yet, or
No, they do not.
not yet?
At this point, no.
Okay. Okay, we'll reschedule it and put in your order that you draw that the parties should come and have any witnesses, and we'll have a hearing on that same day, okay?
Okay, I'll do that.
Okay, thank you.
So I'll see. you
The
just
Anderson
probably-
case that was next has been settled.
Yeah. you're right.
Okay, is there any case that we haven't addressed yet? We got a confidential matter that's coming up.
Your Honor, if I could have a few minutes before we start that.
Now, who is this lady here? Is this,
This is my client and I haven't got to talk to her yet. Oh, she's leaving.
yeah, and how are you connected to this?
I miss better.
Okay, okay, well, there'll be a full hearing on it next month, okay?
Thank you, sir.
Okay, confidential matter that's coming up.
If I could, I'd not let her talk to my client if I could speak to her real quick.